Do you dare to follow me down? Head into the unknown, down the rabbit hole, where it stops no one knows. We're going
Hello, everybody, and happy Tuesday, and welcome back to Criminality. And this is your first time here, welcome to Criminality. So, today, we're back to Delphi. Oh, goodness. A couple filings from the state and a new one from the defense. So, let me say hi to everybody, and we'll get started, because I know a couple of you guys in chat said you got to head to work. So, we'll keep it moving. So, hi, Scott. Oh, well, thank you very much. Hi, Gambies. Hi, Adrian. What's up, See-Through? Hi, Dina. Jen P. Just in time, y'all coming with me to Costco? All right, I guess. So I have to go to Costco. Hi, Mark. Hi, Queen. You're going to be a lurker? Yeah, lurker. Hi, Tony. What's up, Scully? Hi, Cleveland Rocks. Hey, Shiraz. Hi, TT. Hi, 1960. What's up, Just Deb? Journey takes a trip. Hi, Fiend. Hi, Lorna. Caitlin. I don't know. Did I say hi to you, Caitlin, down there? I don't even know if I did. See, this is when I start to lose track of what I've done. Hi, Katie. Hi, Hello Spring. What's up, Susan? Hi, Teresa. And all the Teresas as the Teresas come in. Hi, Robin. Hi, Kira. Hi, Coventina. Just I'm gonna go with Tina. Supuri. What's up, Sleuthy? Christy. Black Swan. All right, what's up over here? Let me go back down to the bottom. See who's coming in. Hi, CJ. What's up, Bill? Hey, Grave Evidence. Good luck lurking, because this is going to be good. Hi, Lone Pony. Idaho Charlie's in the house. Okay. All right, let's pull it up. We're gonna get right into it. People are late. They're just gonna have to start from the beginning. No time for shenanigans around here. Oh shoot, and I had shenanigans too. No, it's okay. We'll do shenanigans later. All right, here we go. Here we go. Let's turn that off. Hey, Ramblin'. Nothing but shenanigans. Shenanigans. It's some shenanigans over here. Okay, so the first one is a filing from Nick. Well, who knows if it's really from Nick, but he signs it. It comes down the state of Indiana by Nicholas C. McClelland, prosecuting attorney for the 74th Judicial Circuit, and moves the court for an order for Rushville Police Department. Attention, the chief, Craig Tucker, to produce to the Carroll County Prosecutor's Office, attention, Nicholas McClelland, 101 West Main Street, and all employee records, any and all employee records for Todd Click, associated with his employment at Rushville Police Department. While working the Delphi investigation, Carroll County Sheriff's Department Detective Tony Liggett developed information that Richard Allen was involved in the murders of Victim 1 and Victim 2. During the investigation, then Rushville Assistant Police Chief Todd Click, I wonder if this is intentional because, you know, we all call him Nicky, little slick Nicky. Chief Todd Click participated in following up on leads and interviewing parties associated with those leads. The defense has listed Todd Click as a witness they intend to call during their case in chief to express his belief that other people were involved in this crime. The state believes that Todd Click has employee records that will show a Brady, I hate this word, it's like Giglio, because it's not how it sounds, or it's not how it's spelled. It's like Giglio, it's Italian. Violation that could call into question his credibility as a witness. The violations could also call into question the veracity of his testimony. No, it's not a G. It goes with a J. It's a J sound. I know that part. It's like Giglio. Veracity of his testimony. Based on this information, the state has filed a motion for leave to obtain these records. The state is requesting the employee records, mental records for Todd Click for his employment at Rushville Police Department specified in the attached subpoena, and or a request for production of documents. The request is made for the purpose of preparing for trial in this matter. The state believes that Todd Click will be a witness called by the defense to support their theory of the case. The state believes the employment records of Todd Click are relevant and would assist in the state preparing for trial. The state of Indiana has contacted the defense in this case, and the defense does not object to this subpoena and would waive the 15-day notice requirement. So, hi, everybody that's just popped in. So, essentially, Nick wants all of Todd Click's records. Is this super out of the ordinary? Not necessary, but I think it's quite interesting that he's going to try to throw him under the bus for something in his past, or that's what he's intending to do. So I think it's interesting that he's obviously been digging into Todd Click. And Todd Click being one of the only witnesses so far that Nick really seems to have an issue with. And that's just an interesting thought on why does he have such an issue with Todd Click. In the bigger scheme of things, I have to ask you guys, if it comes out that there is some type of violation, a Brady violation that was done by Click, what does that do to the Rushville Police Department? Or more importantly, what does that do to the prosecutor's office in Rushville on any cases that Todd Click has testified about and that information wasn't out there? So I'm wondering how far this could go and how big of a deal this could become to that prosecutor. Now, if it's not a big deal and they just have, here's whatever the warning was, and it is what it is, and he just had a warning about something that he had failed to turn over at this point and then turned it over late. I don't know. I just wonder. I wonder what that would do. And then the next part is, in the bigger scheme of things, which I'm surprised they actually haven't, because that's a big part of their third-party defense, is this lack of investigation, requested like Liggett's records and Holman's records, that the defense hasn't requested those yet. Click will still testify, yeah, for sure. I don't think that's not going to do anything. They want to try to use it against him. I also feel like it might be a little bit of an intimidation factor. Like, keep going, Click. Keep going with this, and all this about you is going to come out, and your stellar career is going to be put on blast in the courtroom. Cleveland. Oh, I apologize. So Brady violation is in any type of information, exculpatory or inculpatory, has to be turned over to the defense. And in order for the prosecutor to do that, it has to be turned over to the prosecutor. So let's let's think of, I'm going to give you, this is a very rough example. So let me just kind of give you this one in context of something that you probably know. When Holman knew who Professor Turco was and was doing these interviews with Professor Turco, and let's say, you know, in my thought process, like Nick wasn't told that he actually knew who it was and wasn't told about these interviews and so on, then Holman would be committing like a Brady violation. He would not be turning over the evidence to the prosecutor in order for it to be turned over to the defense team. Does that make sense? That's why I said it's a very rough example, but that's like one that I can think of more recently that could have turned into that. I checked Indiana's Brady register and Click is not on it. Well, if he wasn't actually found to have a Brady violation, he wouldn't be on it. But I'm just thinking, like, if there was some type of warning or... Right, Travis? Hi, Travis, by the way. Yeah, it could... I'm thinking that it could be a big deal for anything that he's... If there is something like that and it wasn't turned over, I don't think anything will come of it, but Gold will probably grant it. Well, probably. I mean, the defense isn't objecting to it. So they obviously know whatever it is, and it isn't a big deal. They're just like, yeah, go ahead. And it's probably, like I said, it's probably he's not on the Brady list, so it's probably some type of warning, or something that was investigated and found to not be substantiated. That's kind of, we don't know. Obviously, I'm just kind of taking a guess at what I think it could be. Sorry, this popped in my brain. Wasn't there a huge issue with late discovery by Carroll County in a totally different case we talked about like a year ago? Oh shoot, I don't know. My brain isn't going that far back right now. What did we talk about like a year ago? You'll have to remind me. Somebody in chat might remember. I believe Click over Nick any day. Now, it wouldn't be a warning he'd be violated or not. Well, I think that there would, I mean, it doesn't necessarily, because like when I was looking up like what the reprimanding for an officer in a Brady violation would be, it does say that they would be like, they could be investigated and it come out to be nothing. But no driving, so no lurking until work starts. Then I will replay crew if we are busy. It could mean that there's evidence that he did not turn over in a different case, and that's what they're trying to get. But I'm wondering why they're trying to get his mental health records. Is requesting the employee's records, mental records. Employee records, mental records for Todd Click. Gave him 30 days to comply with the request that would place the handover until after the trial. And Travis says a Brady violation isn't something that's usually tracked in that manner. It's usually an officer is on a Brady list, and that's something that results from an internal investigation typically. Yeah, Sleuth. Yeah, I was thinking that too, but I wasn't sure. That Gold's daughter, when she was at the prosecutor's office, had something. The mental thing could be a mistake. I don't know. It's weird. The Brady list is just any dishonesty by an officer that could call into question their credibility on the stand. Okay. Like dishonesty allegations. Oh, you think it's an error too? You think it's an error too? The state is requesting the employee records And then you think mental records just should, this whole part right here just shouldn't be there? You don't think it's employee records and then they're just missing the word and mental records for Todd Click for his employment? They just like copy and pasted and just it has mental records still in here. All right, well, we'll have to see what comes of it. But like I said, the defense isn't fighting it. They're like, yeah, go ahead and get the records. So no big deal. It is what it is. And then let's see. Somebody said that was 30 days. I didn't even read down here. They might have 30 days legally, and there's probably might not be anything they can do. Let me see. He writes it all up for him already. Let me see. I think Sleuthie's probably sent me something. Okay, hold on. So Sleuthie has this on Twitter. Interesting old news out of Indiana. Judge Goals. I'm going to close that real quick just so it doesn't keep popping up. Judge Gull's daughter, Christina Gull, was a prosecutor in this case. She subsequently left the Hamilton County Prosecutor's Office shortly after this and moved to the Allen County Prosecutor's Office in December of 2022, where she remains today. The case reached a premature end in June, however, when a judge discharged Whitmore because police and prosecutors failed to hand over more than 10 terabytes of digital data, the rough equivalent of 64 million pages of evidence, from electronic devices associated with Whitmore and the teen in a timely manner. Hamilton Superior Judge William J. Hughes wrote in December order for the delays were so egregious and so extensive that they infringed on Whitmore's constitutional right to a fair trial in the judicial system. This failure occurred even though multiple requests were made for the data extraction reports from the defendant's electronic devices seized by the state and kept in evidence for 4 years. Hughes wrote, prosecutors made multiple false representations to the court and Whitmore's legal team, claiming that everything the state had been produced. As a sanction, the prosecutor's office was ordered to cover the $105,000 of Whitmore's private attorney costs. This might be the one that you were talking about. Maybe we talked about this last year. So that's interesting. I don't know. I'm not familiar with the case. I don't know what her role was on the case. I don't know if she was a lead prosecutor or if she had come in to help out. But I mean, still, she would have been part of that team. That's tough. That's a tough one. I mean, talk about violations. And then she goes to Allen County where her mom is a judge. Dun dun dun. Is Hamilton County in Baldwin's home? Is it? I don't know. I don't know the counties out there, so that would be a good question. Probably easily look that up. But he's in Franklin, right? Let me see. Franklin, Indiana. I think that's Franklin County. Is Franklin in Franklin County? No, it's in Johnson County. So Franklin is in Johnson County, it says. Hey, True Crime Time. What did they learn in 2019 from LG's phone they did not learn in 2017? Great question. We haven't got there yet. Hey, Princess Buttercup. Are there any counties here without any fuckery going on? I don't know. I think Indiana needs some more transparency on what's happening with their system, because it seems that there's a lot of shadiness going on. Okay, so we have next Nick's response, essentially his answer to the defense's motion to suppress that they filed on April 11th. Let me see if I still have that one up. This one. So this is the motion to suppress statements. We had read over this like a week ago. In the memorandum in support of it. Okay, so that's the one that we're responding to today, is the one from April 11th. Now comes the State of Indiana by Nicholas McClelland, respectfully objects to the defendant's motion to suppress filed April 11, 2024, and would ask the court to deny the same. In support of said motion, the state would ask the court to consider the following: that the state has provided the defense with statements of Richard Allen. Those statements include phone calls made by Richard Allen to his wife and his mother, and statements that he has made to the Indiana Department of Corrections staff and inmates. The statements made to Indiana Department of Corrections staff and inmates, referred to as suicide companions, consist of statements on quote-unquote door sheets. These door sheets are forms provided by Indiana Department of Corrections for monitoring the behaviors and statements of Richard Allen at a frequency determined necessary by mental health personnel. That the state has identified and provided the names of all the suicide companions which the state intends to call as witnesses for confessions and relevant statements against his own interest, which includes 16 correctional officers, 8 inmate companions, the warden, mental health personnel, and Indiana State Police officers. All right, so let's talk about this for just a hot second. They're called suicide companions. A Brady cop is simply a cop that prosecutor has to disclose something about to defense counsel in any case where they may be a witness. The DA office maintains Brady lists of those Brady cops. Right. But my point is he's not on it. So then what happens to the cases since then if he wasn't actually on this list? I don't know. I think there could be some fuckery afoot there. But we don't know. We'll have to wait and see. Oy vey. This is Nick's response to the April 11th motion to suppress. Yes. So I'm really interested on what you guys think of the fact that the state intends to call 16 correctional officers, 8 inmate companions, the warden, mental health personnel, and Indiana State Police officers. Daniel, yeah, there's like 3 new motions that came out today. 2 from Nick and 1 from the defense. We're on the second one from Nick. "16 correctional officers." So I don't necessarily, I think that this is going to end up being, one of those, it's not, he didn't tell all these people. What I think what's going to happen is that these were the ones who had to review the tapes, or these are the ones who had to review the reports, or were in charge of the inmate companions. And then you have the warden who's in charge of all of them. Even though we did hear rumor for a long time that he had confessed directly to the warden. The mental health personnel, which is another, thing that we'd heard. We heard medical staff, but that we went back and forth on what the difference between the medical staff and the mental health staff would mean. But I find this one interesting. The Indiana State Police officers. We know he didn't confess to any Indiana State Police officers. There's no confession when he spoke to any of the officers. That he doesn't. The closest thing they can say to a confession would be his mere presence, him saying he was at the bridge that day, and that's really it. But it's just an interesting thing because he's interviewed the first time on October 13th. He's interviewed by Liggett and Mullen. Liggett is Carroll County Sheriff, and Mullen was the Delphi Chief of Police. And then the one that was brought into question from the defense was his interview with Jerry Holman. That's the one they want suppressed for that. So what are these Indiana State police officers? What's that about? Oh yeah, Shmita, she really would. The warden is a lying motherfucker. His captors and his abusers. What a bunch of crap. He wants the defense to freak out and wants to take more time to depose these guys. I mean, like, let's be real. You have Richard Allen, who you've put into solitary on suicide watch, and yet he has the ability to talk to 16 different correctional officers, 8 different inmate companions. The warden goes for his mental health checkups, and somehow, while he's locked up, is having conversations with Indiana State troopers or Indiana State police officers. That's why I think that what's happening is he's putting all these people in here because, and I'm going to tell you exactly why, because he's going to actually say it about the defense here coming up soon. But I do think that these are all the people that were interviewed regarding this. That like I said, like these inmate companions report to these certain correctional officers, and so they're going to testify about the inmate companion program, and he's not running around the jail, he's not running around the prison doing all kinds of stuff. Like, it doesn't even make sense. ISP transport. Okay, ISP shouldn't be transporting him. The Department of Corrections should be, but we do know that during that last hearing, she actually ordered Liggett to transport him. So he shouldn't be transported by ISP. If anybody actually knows if he is, that would be an interesting thought. Okay, so and then the other thing is what are they going to bring one up on the stand, say, did you hear him say this? Yes. Okay, thank you. For the next one up on the stand, did you hear him say this? Yes. Did you read the report where he said this? Yes. Because otherwise, I mean, you're talking 24, 25, even if we go with one here, 26, 27, but it's plural. 27 people that they're putting on the stand. And we have a 2-week trial. If that's your biggest, if these confessions are your biggest evidence that you're going to spend that much of the trial to put that out there, and from what we know of at least a couple of the confessions, they're not accurate. It's not accurate info. We don't know the other ones. I want to make that very clear. Now, if he is out there just running around telling 27 people that he did this, and in one of those confessions, he's telling what actually happened, or some type of, the something only the killer would know kind of thing. I mean, it's just such a weird thing. It's almost like we have all these people who are going to testify, and like I said, I'm going to tell you exactly why I think he's doing it. So the admissibility of a confession is controlled by determining from the totality of the circumstances whether the confession was made voluntary and was not induced by violence, threats, or other improper influences that overcame the defendant's free will. The same test determined whether Miranda rights were voluntarily waived. Thus, this is all the case law that he's putting in here to support his, what he's having to say. Thus, the voluntariness of a defendant's waiver of rights is judged by the totality of the circumstances. An express, written, or oral waiver of rights is not necessary to establish a waiver of Miranda rights. So the Fifth Amendment's privilege against self-incrimination applies to the states through the 14th Amendment. When a defendant challenges the voluntariness of a statement under the United States Constitution, the state must prove by a preponderance of the evidence that the statement was voluntarily given. And he's saying it right here. The state must prove that the statement was voluntarily given. This is exactly what the defense is saying is not happening. It is not voluntarily given. You've coerced him, and by almost a type of torture to give it. That's not what I'm saying. That's what the defense is claiming. So, in addition, the Indiana Constitution provides that no person in any criminal prosecution shall be compelled to testify against himself. The Indiana Constitution requires the state to prove beyond a reasonable doubt that the defendant voluntarily waived his rights and that he voluntarily gave his statement. Hold on one second, you guys. Okay, sorry. My husband got me a soda pop. So, oh, you guys can barely see this. All right, let's see. Fitness for duty, mental and physical, are typically forms generated by state authority that the licensed peace officers in a state. A box is checked. Some have them to do MMPI at part process. Okay. Where was I? Here, Indiana requires the state to prove beyond a reasonable doubt that the defendant voluntarily waived his rights and that he voluntarily gave the statement. Right. So the state has to prove that he gave all of whatever ones he was giving and whatever was said during these, that they have to prove that he was doing it voluntarily. Well, the defense is saying he wasn't. He wasn't doing it voluntarily. The self-incrimination clause of the Fifth Amendment protects an accused only from being compelled to testify against himself or otherwise provide the state with evidence of a testimonial or communicative nature. In order to be testimonial, an accused's communication must itself explicitly or implicitly relate a factual assertion or disclose information. Absent a custodial interrogation, there's no infringement of the Fifth Amendment rights identified in Miranda and no occasion to determine whether there has been a valid waiver. You know what, Sleuthy? I will absolutely. It is. It's a lot of word salad to say. We think he did it voluntarily, and we're going to call all these people to prove it. Okay. The term interrogation under Miranda refers only to express questioning, but also to any words or actions on the part of police, other than those normally attended to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. We went over this on how to know if you're in a custodial interrogation. Since police cannot be held accountable for the unforeseen results of their words and actions, the definition of interrogation can extend only to words or actions on the part of police officers that they should have known were reasonably likely to elicit an incriminating response. The defendant is being held in pretrial detention for his safety pursuant to court order. Inmates of the PLUS program and subsequently corrections officers at the IDOC holding facility have been assigned to observe Richard Allen and record his behaviors, which has included documenting statements by Richard Allen. Mind you, remember, he's still innocent until proven guilty, and they put him in a prison. And Nick just does not seem to have any issue with this at all. Like, just that he's a normal, everyday guy who they just throw in prison in solitary confinement. And he just is like, yeah, that's just, yeah. So people were just assigned to observe him and write down what he was talking about. But remember, he's put there for his safety from himself and his safety from others, because they don't believe they can keep him safe and get him the help that he needs, in the regular jail. And they're keeping him safe from other inmates. I don't know. It seems counterproductive to me that the assignment of correctional officers to replace inmate companions coincided with Richard Allen being provided legal documents for his case. Therefore, it was determined no longer appropriate for the inmates to provide companion services due to the gag order and discovery protective order. So if it had to do with the case, they didn't want Richard Allen talking about it. But if it had to do with whatever Richard Allen was just saying, then that was fine. That the defendant alleges all his statements subsequent to arrest should be suppressed for the reason that they are all involuntary due to the conditions of his pretrial detention, which they characterize as a legal coercion, either psychological or physical, in violation of his constitutional rights. Statements by Richard Allen, which the defense seeks to suppress, are unsolicited and voluntary, like those in C versus State, where the defendant made unsolicited statement while he was being moved from one part of the jail to another. Such statement was properly admitted into evidence. The defense has alleged that physical coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. The defense has also alleged that the psychological coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. The defendant has not alleged that any of these statements are the result of interrogation by law enforcement while in custody, and the state would assert that Richard Allen is not being interrogated by law enforcement or any agent of the state during his pretrial detention, regarding the charges pending herein or regarding any other criminal activity. I will have you notice he does not deny that some of those things are actually happening. All he says is those things that you're saying are happening don't constitute as being interrogated. But nice try. That's literally what he's telling them. The case law on application of the protections of the Fifth Amendment indicates that absent interrogation by law enforcement or an agent of the state, the defense does not have a basis to challenge the admissibility of voluntary statements made by Richard Allen. Their basis, he's going back to being an interrogation. Well, what they're saying is that he's being coerced. The state acknowledges its burden to show beyond a reasonable doubt that the statement was not obtained in violation of the Indiana Constitution or by a preponderance of the evidence that the statement was not obtained in violation of the United States and the United States Constitution. However, the state does not believe the constitutional protections allow for the defendant to allege that all statements during pretrial detention are the result of coercion directed against him. The posture requires the court to begin with an assumption that pretrial detention in the IDOC by its very nature is coercive interrogation by a state actor, and thereby shift the burden to the state to present testimony to refute illegal coercion for every statement made by the defense. Now, I think this is a tough one, because why was he put there? They say he's put there for safekeeping, but they say he's not suicidal until after he gets there. And then they're saying, like, the defense is saying the whole thing started with the fact that you took this random dude off the street and you threw him in prison. Not only do you throw him in prison, you throw him in solitary confinement. Now, I think that the defendant alleging that the statements are the result of coercion directed at him, which would begin with the fact that he was actually put into pretrial detention, is a big deal. Because that's what they're doing. He was put there to break him, since they had no evidence against him. They wanted to get a confession. I don't know how many people, no matter what quote-unquote side you're on, don't see that. The defendant is making a blanket argument that all statements by Richard Allen are the result of improper influences based on the defendant's mental state without having to address each statement and its unique circumstances. The defense argument ignores the case law regarding application of their cited constitutional protections by skipping over the threshold of showing or alleging interrogation by law enforcement or their agents. The defense motion expects the court to accept that all inmates, employees, and third-party medical or mental health personnel are acting as agents of the state, specifically law enforcement, with the purpose of illegally coercing statements from Richard Allen for his prosecution. The allegations and assumptions are absurd, unfounded, and not supported by the motion filed or any facts or evidence. The motion to suppress all of Richard Allen's statements is another attempt by the defense to derail this case with conspiracy theories and inflame the public to believe the government has unjustly pursued charges against Richard Allen. Just take that in for a second. That it's another attempt by the defense to derail this case with conspiracy theories and inflame the public to believe the government has unjustly pursued charges against Richard Allen. Like I said earlier, that he would make a statement that is exactly why I think he put in there that he has 18 correctional officers and 16 correctional officers and 8 of the suicide, companions. That's why he put that in there. That's to try to knock the defense off of whatever pedestal Nick believes that the public has put them on. But I think Nick seems to forget that when he got rid of the attorneys, 2 other attorneys came in, and one of those attorneys went to go visit Richard Allen. And that attorney, Mr. Librato, didn't really have any reason to just buy into the defense theory, if you will. And he was done. And he came out publicly afterward and said, I've handled a ton of murder cases, and I have never seen anybody put in prison and treated the way that Richard Allen is being treated. So this whole defense is to derail the case with conspiracy theories and inflame the public. I go back to, why didn't you just move him then? Why didn't you just let the defense move him when they had the opening in Cass County? Why didn't you just let him move him? Instead, you argued that there wouldn't be enough basketball for him to play because Richard Allen plays so much basketball. To me, the public should be inflamed if that's what's happening to Richard Allen. Now, he says, the defense doesn't prove it. They don't have anything to back up their statements. The public knows that Richard Allen was put into a prison, and not even one of the good prisons, like one of the worst prisons in Indiana. Let's be clear. Let's be clear about what Westville was. One of the worst prisons in Indiana. Before he's convicted of anything, the public knows that there was an opportunity for him to be moved to a jail where he could have still had all of his mental health taken care of, and he could have been in an actual jail, even though they didn't want him. They said they'd take him. The public already knows that. The public also knows what Richard Allen looked like when he was arrested and what Richard Allen looked like when he went to his hearings. The public knows that. So I believe for a lot of people, it's very easy to believe what the defense says because they now have, and even at first when people were like, I don't know, you know, maybe, and then you got Librado who comes out, who's got no more, you know, what do they call it, dog in this race, and he still says, no, I think the guy's innocent. I think these people are dangerous. They're scary. I think they sacrificed one girl and killed another. And I've never seen anything like what's happening to Richard Allen ever happen to anybody I've ever represented in all of my years. So now you not only have Baldwin and Rosie who are like, this is absurd. You have another attorney who comes in and says, this is absurd. And I would love to know why Nick thinks it isn't. And what happened here is Nick actually says it himself. It's his responsibility to prove it beyond the preponderance of the evidence. It's the state's responsibility. It is not the defense team's. So, but I do think that whole little, oh, well, there's 16 of these and 8 of these and all these, we're having all these people testify. No, you aren't, Nick. You got a week. You get a week to have people testify. You're not having all those people testify. What, you're just gonna parade them in? What did Hennessy say? Well, one, it's not a parade. They're coming one at a time. Anyway, and this, like I said, this is where people will be like, see, look at, you're like, so Richard Allen is innocent. And I'm like, no, this is bullshit. And I would like to see if any of these people would be okay if they are at the location where a murder happens and then they are put into the prison system. I got you, Nikki. I got you. Well, yeah. And I don't foresee, I don't know if anybody does, I don't foresee her ruling in favor of anything with the defense when it comes to this stuff. Now, the big one that I think she should be looking at is probably that second interview with the Miranda rights, because I do believe he was in a custodial interrogation, but that's me. Other people say they don't believe that he is. So the state requested the defense be required to identify the specific statements. I did like this. I was like, all right, Nick, I see you. The state requested the defense be required to identify the specific statements of Richard Allen that were illegally coerced and identify the state actor whose conduct supports the allegations of coercion and describe the conduct they believe to be either physically or psychologically coercive before the state is required to respond for further analysis by the court. So, I sleuth intuition. If what the defense says is true, that is upsetting, but it isn't. They are there to change the narrative for Richard Allen. It's literally their job. But you have to weigh that also with the fact that the prosecutor, that is literally their job. His job is to put out to the public that he is right and to show that they got the right guy. So, I mean, when we say like it's their job, it's both their jobs. That's why you have to like read between like what's actually happening and go with what do we know. And that's why I was going over like as the public, this is what we know regardless of what Andrew Baldwin and Brad Rosie or even Librado say. We know those things to be true. Just as the public. Because I mean, they're lawyers. I mean, let's be real. They're all lawyers. They're all pushing out documentation to support their narrative. They're not putting out the evidence. We don't get to see that yet. You know what I mean? So it's all it is. It's all written narrative by each side to show us that they're right and everybody else is wrong. It is signed by Nick, but reads like Diener. I agree with you. But here, so this last statement, I thought this was actually pretty badass. If it's Diener or if it's Nick, I actually really did, because if there's this many statements, and we've heard, like I said, we've heard rumors and rumors and rumors about different confessions to different people and so on and so forth, and now they're calling in these 16 correctional officers, these 8 suicide companions, and so what Nick / Diener is doing here, I thought it was actually pretty good, because he's saying to the defense team, all right, so you're putting out specific ones that you're picking and choosing, and I see what you're doing here. You know, you're putting those out because you want the public to see it and you want them to see how bad it is. So go ahead and write down all the confessions. Go ahead and write down all the confessions and what they say, and then tell us how he was coerced. And I was like, that's an interesting one for me. This actually made me raise my eyebrow and go, okay, obviously Nick knows. Oh, this ain't Diener? You don't think so? I think it reads a lot like Diener. The whole circle talk, that was more Diener to me. But either way, Nick signs it. But I thought this was actually really good, because I'm like, okay, if there are these actual confessions where he's saying, you know, I did it and this is what happened, or they're more legit than this whole, you know, generic confession we've been, you know, keeping told about. He's telling the defense right here, you want to say that he's coerced? Go ahead, write down all the confessions, write them all down, and then tell us how he's coerced for each one, and then put that shit out in the public. I don't know. I thought that was really ballsy, and I was like, that made me lean towards, okay, what other confessions are there? The state requests the defense be required to identify the specific statements of Richard Allen that were illegally coerced, and identify the state actor whose conduct supports the allegations of coercion, and describe the conduct they believe to be either physically or psychologically coercive before the state is required to respond. I don't know. I thought that was pretty ballsy, because he's saying here, you're going to write down what was said, write down what was said, and then write down that this person and the legal standard of what they physically or psychologically, how they physically or psychologically coerced him into saying it. And then he's like, then I'll respond to you, because you're not going to do it. That's kind of how I took it. Like, you're not going to do that. In the absence of specific allegations by the defendant as to each statement against his interests, that is involuntary as a result of law enforcement interrogation. The state asserts that the defendant has not sufficiently identified statements subject to a motion to suppress. Wherefore, the state requests the court just deny defendant's motion to suppress statements filed on April 11th as failing to state a claim for relief under the 4th, 5th, and 6th Amendments of the United States Constitution and of the Indiana Constitution, absent a more specific statement setting forth with specificity. Guys can all drop the emoji, all you channel members, get some specificity in there. The statements obtained during custodial interrogation by law enforcement or their agent. I do think that the defense would very much win on the fact that these people are their agents. I mean, they're working in a capacity, even with the suicide companions. It's their quote unquote job to be the suicide companion. Now, you're working as a state agent. The facility is a state facility. Hold on, let me pull. I closed it so that it wasn't dinging at me all the time. So let me pull it back up, Sleuthy. Okay, hold on. Okay, so let's see this. Oh, this is interesting. Can I share this, Sleuthy? Is that okay? Not allow gamemanship on the part of prosecutors. This says 2 recent opinions, Maryland v. Schatzer and House v. Fields. The Supreme Court concluded that the inmates serving prison sentences were not in custody for purposes of Miranda. Hold on. You guys just hear her dinging. Ding, 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 ding. In this document. Okay. Here, I'll put the document in here. You want to? Oh, you have the link. You want to just drop the document in the chat too? Okay, so Ange from the Unraveling sent this. Let me just pull it up on the screen so you guys can see it. Okay. The article maintains that the court's language and reasoning in Schatzer and Fields, as well as the relevant policy considerations, call for limiting the reach of those opinions to prisoners serving time. This article therefore concludes that pre-trial detainees should be deemed to be in Miranda custody for the duration of their confinement prior to trial. Any other result would allow gamemanship on the part of prosecutors in making charging decisions and bail recommendations, and would enable law enforcement to trade on the coerciveness of pretrial detention to elicit unwarned confessions. And I don't know if you're listening, but this is perfect. I mean, it literally wraps it up. Law enforcement to trade on the coerciveness of pretrial detention to elicit unwarned confessions from suspects who are especially susceptible to the threats and promises that are a leading cause of false confessions, and who disproportionately represent communities of color and financially vulnerable populations. Let me find where I put you guys here. All right, I found you guys. What can I say? I move fast, like lightning. I believe RA will try to hurt himself the first chance he gets. That will not be helpful in any way. That is what happened in county jail. Well, I mean, I think that when somebody wants to do it, we've seen circumstances where they do it in prison as well. So I just think that's a tough call, and I think that it's smaller. It's a smaller facility, and the whole thing behind, and this is I know we're not going to know the answer to this, Sleuth, until the mental health examinations come out. But essentially they're saying because he was put in prison is what made him suicidal, because of the conditions he was in. Now the opposition says no, he's suicidal, so he needs to stay in prison and be watched. I don't know if we will. I don't know if we will be able to know that as the public until these people actually start coming out and talking about what these evaluations looked like, when things started being said, how things transpired. But I guess I look at it so personally when it comes to that, because I just think to myself, if I was just taken as some random person off the street who just says I was there at the time, or I was there at the same place that a crime was committed, and you take me and you put me in solitary confinement in a fucking prison, you don't give me my medication, and I'm, like I said, we're not going to know the truth of the matter until it gets there. And that's why I constantly say the whole thing, and why I think that people on social media end up fighting with each other, is because of trust. People trust different people, and the other people don't trust them. And so it becomes like a fight between like us on social media. And I have to be very clear again. Our opinions on social media are literally that. There are opinions on social media. We do not affect the outcome of what those 12 jurors have to say. Like, my opinion here on my channel today is not going to change what the 12 jurors who are picked to sit on that trial are going to decide. It's just my opinion. They're just my questions. The only people that my opinion matters to is you guys, but I'm thankful my opinion matters to you guys. But I try to remind people of that. But I mean, this is saying, like, no matter where they are, prison, pretrial detainees, no matter where they are protected by Miranda. So Nick is essentially saying that he's not protected by Miranda, but he's also throwing out there that none of these people should be considered state agents because they're not law enforcement, and that therefore this is not an interrogation. So I'll read it. So the article therefore concludes that pretrial detainees should be deemed to be in Miranda custody for the duration of their confinement prior to trial. Any other result would allow gamesmanship on the part of prosecutors in making charging decisions and bail recommendations, and would enable law enforcement to trade on the coerciveness of pretrial detention to elicit unwarned confessions from suspects who are especially susceptible to the threats and promises that are a leading cause of false confessions, and who disproportionately represent the communities of color and financially vulnerable populations. So, I don't know. It's so tough because I just don't know. Well, you know, this is Maryland. Oh, the Maryland Supreme Court? The Supreme, or is this the United States Supreme Court? Did I miss that? Maryland v. Schatzer. The answer is always Vit. The Vit. They shipped his ass off to the DOC and mailed his letter days later. Jails don't get corrupt because nobody's there very long. Not enough time to make shady plans. Does anyone have a link to the 3 new documents? I can't find them on Twitter like normal. Yeah, Daniel, I'm sure that Sleuthy can drop them probably straight in chat because she's a wrench, so that her links will work. Or Hybrid, and hi Hybrid, I didn't realize you could drop them too if you have them. I'm just reading through chat real quick because I wasn't paying any attention to the chat. I'm the king of the pod. I'm the king of the pod with my face tattoo and my Odin patches. The installation of DOC prisons is what makes the corruption and abuse so prevalent. Right. Out of sight, out of mind. Well, the thing is that human nature is really to kind of go for, you know, an eye for an eye, or at least, you know, some type of something very close to it. So once people are convicted and locked up in prison, most of humanity just doesn't really give a shit about them anymore. I mean, like, I don't mean that mean. I just mean there's very few people who are like, oh yeah, let's care about, like, even we'll just talk about like Bastin for a second. You know, he comes out and immediately everybody's like, what are his charges? He's a child killer. Like, who gives a fuck what he has to say? You know, who gives a fuck what's happening to him? And I don't disagree. I don't disagree. So I think that's the other thing is, like, when it comes to like corrections, people aren't overly interested in changing it. I mean, the majority of people, I should say, are not overly interested in changing it. It becomes more relevant to society when it's, one, their family member or a loved one, and two, when it's a case where the public sees injustice and thinks that the person that they're talking about, even if convicted, is innocent, and what that person might be going through because they were wrongly convicted. But I mean, like, seriously, like, how many people here, you get child molesters that are locked up and put in prison. How many of you guys care what happens to them? It's a very few. I'm telling you, it just really is. Most people don't care. So they think, like, okay, Richard Allen's put in prison. Most people aren't going to care what happens to him. Most people aren't there to check. Most people aren't looking. Nick just pissed off a lot of LEOs. Oh yeah, I think so. I think so too. And I would assume he probably pissed off the Rushville prosecutor's office. That's just my thought. So, but I mean, I don't, like I said, we haven't seen it yet, but I can imagine that we're going to see, them asking, the defense asking for the same when it comes to Holman and Liggett. And they're going to be like, look, hey, we didn't argue with your subpoena of the records. Why are you arguing with ours? Like, what's the difference? I think it's a play, but that's me. Because a lot of this stuff is. He's convinced that Gull's going to let him do whatever he wants. The whole middle of this was a lot of word salad. I agree with you. Yeah, let's get Doolin's. Let's get Doolin's history. Nobody wants that out there. All right, so let's go to, those were the two filings from Nick that came out today. So he's asking for Click's employment history and any records that he had from Rushville. And then he's saying, did you read the motion to compel yet? To yourself. No, I have not touched this at all. I have no idea what's in this. I have not read it. The other two I had read. This one I had not read. I was picking up kids and then I came home and went live. So this one's brand new to me. I have not even peeked at it. So this should be fun, right? Calling Click's honesty into question could also destroy his career as a parole officer. Yeah. What defense attorney would bring up their client's Brady list status when he revokes their parole? Ooh. T is in for a treat. This is the bombshell one. Get ready, T. Okay, I'm ready. All right, hold on. I'm not ready. I'm going to take a drink. Wait. Just skip to the third page. Okay, hold on. No, I'll read it. You wish I could have AI read it to me while I react? Well, do you want to come up and be AI? And you can read it while I react? I hope that Click takes a digital. That would be fucking badass. If Click walks into McClelland's office and he's like, "Here you go, sucker." I do. People say like they're auditory learners and then some are visual learners, so they want to read it. Other people want it read to them. I prefer all the above. I like listening to it, reading it. And I mean, I like everything. I'm visual and auditory. I like to hear it and read it. That would be badass. Somebody get Click on the phone. Be like, go get your file and go hand it to him. You gonna come read it like a robot? You don't have to. I'll read it. I can read it. You can. I mean, you can if you want to. But... You want me to turn on my camera so you can see my reaction? Okay. I'm just tiny over here in the corner though. Okay, so introduction. So now this is a filing from the defense. Send him a certified letter to request it. Send the link? Okay, I will. Let me grab it real quick. Well, and a lot of the times, like when I get them, I read them first on my phone. So there are sometimes like where I'm like, wait a minute, did I actually read that? Because it was so tiny, I'm like skimming through it. Let me grab a link for her. Let me find you, Sleuthy. There you are. Oh, shoot. There we go. Okay. It's just the recap. Okay, fine. That's the word too small and close to see on my phone. Yeah. Okay, so I'll just read through this while Sleuthy comes up, and then she can read. This is just the introduction, and it's just the for his Facebook accounts. Oh goodness. Well, I mean that's part of the investigation. I would love to, if they would subpoena Click's Facebook accounts, then I would definitely want to see Holman's. I want to see Holman's. But okay, so I'm gonna read through. I'll read through this, and then Sleuthy can come up and she'll read the rest of it. So this, you guys are saying this is just like the recap. I wasted paper like a real lawyer. Okay, October 28th, the state of Indiana, by its prosecuting. Hold on. Okay, I'm going to close this so it won't ding anymore. So if you guys send me something that I need to look at, you're going to have to tell me so I can bring it back up. Okay, so on October 28th, the state of Indiana, by its prosecuting attorney Nicholas McClellan, charged Richard Allen with 2 counts of murder. Mr. Allen's initial hearing was held on October 28th. On November 14th, attorneys Bradley Rosie and Andrew Baldwin entered their appearances in this matter on behalf of Mr. Allen. Pursuant to Rule 2.5 of Indiana Rules of Criminal Procedure, the state must disclose and furnish all relevant items and information under Section B2 to the defense within 30 days of the initial hearing. An appearance by defense counsel or an appearance by pro se defendant, whichever is later. Indiana code state that state must disclose the following information within its possession or control: the names and last known addresses of persons whom the state intends to call as witnesses, with their relevant written or recorded statements, any written, oral, or recorded statement made by the accused or by a co-defendant, regardless of whether charged or joined, and a list of witnesses to the making and acknowledgement of such statements. AB, why is there no C? Why is there no C? Sluty? Hold on, just got some. Okay, she's going to set up her mic. All right. Why is there no C? Because C is not relevant? That's weird. But there's like a space for C. Like it's just taken out. Skipped it, not relevant. Okay. Any reports or statements of experts made in connection with the case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. Any books, papers, documents, photographs, or tangible objects that the prosecuting attorney intends to use in the hearing or trial. Any books, papers, documents, photographs, or tangible objects which were obtained from or belong to the accused. Documents produced pursuant to Rule 1.4. Okay, and number 6, additionally, the state has the duty to disclose evidence which is favorable to the defense. That's all your exculpatory Brady. The above information was due to the defense 30 days after Baldwin and Rosie entered their appearance. Therefore, it was due by December 14th of 2022. Motion for sanctions. General facts. Let me scoot this over so it's centered. There we go. Number 8, between September 8th, 2023 and October 6th, 2023, 9 months after it was due, the state of Indiana sent the defense 14 hard drives, 5 flash drives, 3 DVDs, and a partridge in a pear tree, and several emails containing discovery disclosures amounting to almost 4 terabytes of information. Before the defense had a chance to review all of this late discovery, utilizing only 2 lawyers and 2 non-lawyers, 3 of whom were not able to work full-time on the case, the prosecutor requested that the defense be disqualified on October 10th, 2023, and the court ordered the defense to stop working on the case on October 12th. According to Mr. Baldwin and Mr. Rosie, did not work on this case again until January 19th of 2024. During that 34-day time frame, from September 8th, 2023 through October 12th, the defense was only able to review a tiny fraction of the massive amounts of discovery that had been dumped on the defense 9 to 10 months after it was due. Attorneys Rosie and Baldwin were reinstated and re-entered their appearances on January 19th. Let me close this over here. Hold on. The 2017 extraction and data and other items of discovery were turned over to the defense on January 30th, 2024. However, it did not appear to the defense that the hard drives were organized the same as when originally provided during their first tenure. And these changes have caused considerable delay in locating certain evidence, if that evidence can be located at all. Additionally, it appears to the defense that the state of Indiana has belatedly disclosed tens of thousands of documents spread through many hard drives. For example, the state of Indiana first turned over the hard drive labeled FBI case 7C to the defense on 10/31/23. After Rosie and Baldwin were off the case, and the state of Indiana turned over the hard drive labeled Orion to the defense on 12/7/2023. After Rosie and Baldwin were off the case. Why are they giving him discovery when they're not there? Okay. After Rosie and Baldwin were reinstated, the state of Indiana turned over those two hard drives to Rosie and Baldwin on January 30th, while the defense should have had those hard drives on or before December 14th, 2022. The defense did not receive those hard drives until January 30th of 2023. Typo. Was that? Because they're saying here they got them on 2024. So that's a typo, right? We lost Luthi. Maybe she'll come back. Hey, Bob. Most of the items found on the hard drives detailed above are not labeled in any descriptive fashion, and many, if not most, of the items, consisting of documents, photographs, and video, have zero context as to what the significance of the documents, video, photographs are. Many of the items are not accompanied by a report or even notes that explain the reason such items are included in discovery. For example, one video shows a man that appears to be dead on a bed being turned over by what appear to be police. There's no context provided as to why that video is included in the massive amount of discovery or what this video has to do with the murders of Libby and Abby. That is just one example of thousands of examples the defense could cite of evidence with no context of why it is related to this case. The state of Indiana has provided it to the defense. What? What? Sleuthie, they're turning over videos of a dead guy in a bed?
Is that like not the most ridiculous thing you've ever heard?
What?
So like, does that, like, I wonder what case that is. Like, so I wonder if there's a protective order on the discovery. Like, is he spreading crime scene photos
Did they accidentally send video from another case that has a gag order on it? That would be fucking ridiculous.
I mean, I don't know how this would be related in any way. A man that appears to be dead on a bed?
Well, maybe it's like they
being turned over by what appears to be police, may or may not be.
He might be dead. They might be cops. We don't even have a clue. They might just be some dead guy that people were recording, and they pretended to be cops. We have no idea. That is
scary.
That is kind of, I mean, it's kind of interesting though. Like, is the guy dead? Now I'm so curious. Like, is the guy dead? Were these real cops? Like I have questions. I want to know.
I do too.
All right. Do you want to read? Do you want to read? Am I at the part where you want to read from, or no?
Sure.
Okay. You have it up, I assume.
Well, yeah, I have my paper one. Hold on. Okay. So 14. Yeah, I must be getting old or something. All right, ready?
Hold on, Travis said everyone be quiet. A member of the defense team is here because Bob. Or is it Sloopy? I don't know. They both get accused of it. So, Chelsea, so now we don't know. It's with some random person that could potentially be dead. We don't even know that they are dead. It only appears to be dead. He might be dead. The guy could be totally fine right now. We have no idea.
And they might be cops. It's hard to tell.
It might be cops.
Like, what do they look like that they can't tell if it's cops or not?
Or Woodson. It might be Woodson.
Maybe that's where Woodson came from. He did apologize for wherever Woodson is out there.
Well, maybe that's what is like this potential dead guy. I don't know. We need to get some clarification on this dead person.
All right, so now we need to react. All right, ready?
Okay.
So 14, additionally, more evidence that the state of Indiana has turned over to the defense through e-discovery contains evidence that is seemingly sandwiched in the middle of completely unrelated discovery. For example, the state produced one e-discovery response received on March 15, 2024, which included a document labeled Second Half of Delphi 3 Sups. I'm assuming that means supplements, consisting of 341 pages of documents. Most of the contents in this document are reports from Westville Correctional Unit. However, buried among these other reports is a narrative report on page 239 by Detective Vito of the ISP, describing a phone call with a Detective Lydell of the Manatee County, Florida Sheriff's Office, detailing an investigation of a third-party suspect known by Unified Command in this matter. I wonder which one.
Okay, Detective Vito of the ISP describing a phone call with Detective Lydell of the Manatee County, Florida Sheriff's Office, detailing an investigation of a third-party suspect. What date?
A third-party suspect known by Unified Command in this matter.
I could take a guess.
Well, we don't really know where everyone's at, right? So we don't really know where, like, Johnny Messer is right now. I'm just throwing that out there. I don't know.
Well, Johnny Messer. Yeah, well, he's in Rushville. He posts pictures and stuff from Rushville. So I mean, I guess they could be old pictures, but he does post, or he was anyway.
All right, moving on. Detective Lydell told Detective Vito that the Manatee County Sheriff's Office sent a tech to obtain a pair of a suspect's jeans that appeared to have blood on them, and that Manatee County sheriffs would send the items to the Lafayette, Indiana State Police Post. Additionally, Detective Lydell sent an email to Detective Vito with their report and a statement affidavit. Detective Vito noted that both documents were attached to the report. Neither the Manatee County, Florida report nor statement affidavit were attached to the document the state of Indiana provided to the defense. The defense has not located any follow-up discovery detailing whether the state of Indiana even attempted to test the blood on those pants for DNA, and does not know if such a report exists, and if it does, whether it may be found sandwiched in between other discovery. This is just another example of the discovery issues plaguing the defense. This document would not have been found, but for someone taking the time to go through this discovery one page at a time. Number 15. Furthermore, the state of Indiana has sent repeated piecemeal discovery, forcing the defense to engage in a time-consuming process of reviewing and attempting to search multiple hard drives, flash drives, and e-discovery for particular documents the defense believes exists but cannot locate. The state of Indiana has drowned the defense in late discovery disclosures, which materially harms the defense in preparing for trial in a meaningful and cohesive way. Which, like, is a tactic, you know, but they both agreed to, everyone agreed to a discovery deadline so that, like, this wouldn't happen. And I think one of the things is that would irritate me beyond belief is they turned it all back over, like, in the way that they had already arranged everything. So, like, imagine me getting a whole bunch of fucking discovery and making a whole ass timesheet of every single thing we had, putting it all in order, marking things so we can find it easy, and then we turn it over to you, and then you hand it back all fucked up again.
Well, it's like they
why would it not?
They reorganized it or unorganized it to give it to the new defense team, and that's how they gave it back to Baldwin and Rose.
Like, you'd have to purposely disorganize it. Okay. And I've heard people say, and I agree, like, why didn't they just turn it over to the court? It's not clear why they had to turn it over back to the state. But
No, especially if he gave everything to him. So, I mean, what a disaster. Anyway, and like I said, this isn't a Nick thing. This is a prosecutor thing. They typically do that, just to try to. Now, I don't mean like the back and forth, because that's not even common. But I'm just saying in general, they're not lining it out to say, hey, here it all is. Which I don't understand why not, because they have to do that for the prosecutor. So why wouldn't you just be giving? I mean, do you think that they're turning over all of this stuff to Nick this way?
No, man. No. If I were Nick, like if it were my responsibility to make sure that I didn't get caught up in any kind of, whatever, where someone could say that I purposely withheld exculpatory evidence, like you'd have to be organized and unless you're turning over everything, which he's clearly not doing. Like some states have open discovery. It's called like open file discovery or something like that, where they're like, you know what? It's more dangerous for us to try to pick and choose what we need to turn over. So we're going to literally give everything we have. And I could see it then being disorganized, but that's not the case here. Okay, let's move on to Libby's cell phone. Okay. I'm just going to read with you. I'm going to read on yours.
Okay. I'm going to message somebody real quick.
Do you want me to wait?
Give me just 1 second. Yeah.
Mm-hmm. Also, everyone, I'm like super sorry for the confusion. Angela sent me something and I sent it to Teresa and I was like, make sure you tell Angela thank you, because that's who found it. And then so Angela in chat said, it wasn't me, it was DB. He said it to me. I was thank them both. Everybody's in the chat.
I just sent you a quick message. I'm going to turn this off real quick.
Oh! Snap. Oh, shit. Okay. All right, are we going to move on?
Yep, let's do LG's cell phone.
Hold on, let me plug this computer back in. I knocked it out when I reacted there. Okay.
We should have had you on camera. Not DB Cooper says it's okay. Like they use your drives all the time, so it's okay.
I hate when I like check my DMs late and someone like a week ago was like, hey, I'm going to go live. Like, is it okay if I use your, and I'm like, literally don't ask. Like I put it out there so people can use it. Like you don't have to ask.
Well, like if I can't find it public still, then I ask. Like I asked you about the Idaho one because I was like, okay, I looked through Twitter, but I'm not a good Twitter person. So I was like, shit, I'm just going to fucking ask her. So like if I don't know it's still public, then I was like, maybe it's down. I don't know. And then I'm like, here I am just like, here it is, everybody.
No, I like my Delphi one. I only shared with like 4 people, I think. And like one was, and I was like, don't share this because like it's not. I hadn't like reviewed it. Yeah, I hadn't reviewed it to make sure that everything.
Sleuthy standards. Okay, so Mandy asks, is it common that a prosecutor, instead of explaining how they cleared a certain people's of interest with factual evidence, attacks the credibility of a police chief from another town in the state? That is a great point, Mandy. That is a great point. Yeah. Why wouldn't you just go through?
World, probably, yeah.
Why not just go through and show how he's wrong? And you did actually, because here's the thing is people keep putting out there in the universe that these people were cleared. There's no evidence that these people were cleared. We have no proof that these people were cleared of anything. And if they were, this is what I said about when Click went to ISP in September of 2023, after the Franks memo came out. Why didn't they just show Click? No, dude, like we get where you're coming from and you haven't been on the case for a little while, but like this is all the things that we did to clear these people. Not even if they weren't comfortable telling him the evidence against Richard Allen, because he wasn't actually, working for Rushville anymore. Maybe because they with the gag order, they were just like, we can't really tell you this stuff. But why wouldn't they just nothing to do with them being cleared could have prevented them from just showing Click all of that.
Yeah.
They didn't clear them.
Well, just that, right? Like, we know you're really super concerned, so we're just going to show you how we cleared the people you're concerned about.
Right.
You don't have to get into your whole case. I don't know, man. I don't know why none of Nick's responses are actual responses. They're all just basically, they're full of it. They're
doing this
dramatic.
for the public.
Yeah, but they never answer anything.
Well, okay. So if I'm pro prosecution, I can say they don't need to answer anything because they're going to prove it all in court anyway. They don't care.
But they
don't
do,
care.
though. If they're
don't need
being accused of something in a pleading, then yeah, they do. You know what I mean? Like if you're filing a Tootsie Roll, yeah, you'll probably like it. You know, if they're being accused of something and
Even as a Tootsie Roll.
it's just chocolate.
I thought he was about to do the
Right?
Tootsie Roll. I was like, do the Tootsie Roll.
Oh, great. Now he's going to want to know what that is. They're having a talent show soon.
Oh, have him do the Tootsie Roll.
Yeah, he's like, I can't think of like, he's like, I've got like so many things. I just don't know.
Because it doesn't look like chocolate. It looks like brown poop.
Yeah, it's chocolate. Would I let you eat poop? Try it. You'll like it. But you know,
Don't eat it. Don't eat it. Okay,
It's
so
good.
are we saying the defense didn't scan these documents, and is this 1960 and we're just dealing with paper? No, they put it all on. They put it all on these hard drives, but they just
yeah.
put it all willy-nilly. There's just no rhyme or reason to it. There's no order.
Well, yeah, and like,
I think I'm gonna try the sour more head. Sour yellow.
shh, you're very loud.
If you look at how the state has conducted this case since Rick's arrest until now, this is all the state has done. Attack credibility instead of using facts and evidence. And
True.
attacking art. You're not wrong. But like I said, I mean, like, that's the opposition is that he's just going to prove it. He has to prove it in court. He doesn't have to prove it to the public. I'm just saying, like, that's going to be the common response.
But that's ridiculous because if you are being accused of not turning over discovery now, like, that's not something you're going to argue at trial. You know what I mean?
Mm-hmm.
So I don't know.
Yeah, there's definitely no page numbers. They don't page number anything, and it's all just kind of it's all thrown together, all willy-nilly.
Now he's
Chill.
gonna eat a lemon head.
I'm gonna eat a lemon head. Are they sour?
Yeah, they're sour.
Yeah, I want to taste sour stuff.
They're awesome.
I love sour.
Love lemon heads.
I love sour stuff.
There. Now
Y'all
sit. You're
suck. Now
pushing
I
it.
want Tootsie Rolls, and we don't have any. I don't like Tootsie Rolls. I think they're weird. They're like a
You know what my
Yoo-hoo
mom likes?
candy form. It's
My
weird.
mom likes Rolos.
Oh, I love Rolos.
See, I don't ever eat them unless my mom's here.
Oh, they're amazing. How do you not eat a Rolo?
Like, I don't go out of my way to buy them, but if she brings a bag here, oh, it's not sour. He says it's not sour. So,
Oh, what's your favorite candy?
what's your favorite candy? Oh, he hates Skittles. He hates them.
Doesn't
Spies them.
like
He,
the
like, he
taste of
hates.
rainbow?
My favorite
Dude, he
thing for
hates them.
now. My favorite thing for now is
For
these
now.
lemon heads.
Oh, for now is them lemon heads.
That's your favorite candy?
For now,
Hmm. Does
He
he eat
likes
candy
Pez.
bars? Oh,
he,
Jeremy loves Pez.
you know, recently he's got on to yeah, he loves Reese cups. He loves what are those called? I think they're called fast breaks. Are they the ones with like the nougat inside?
Fast break?
Yeah, but like also peanut butter. Not the thing that has the pretzels in it. The other thing.
I don't know
I think it's
that
a
one.
fast break. I try to buy stuff that I think he's like not gonna like. Or I do stuff like weird shit. Like I like Reese cups, but I only like them in the freezer.
Oh, that's how I like a Snickers. I like a frozen Snickers.
Mm-hmm. So I'll put them in the freezer, and I'm like, he's not gonna like that.
No, he likes
But
it.
he does. Yeah, he
Yeah.
does.
Reese's eggs are the best Reese's of all Reese's. Out of Reese's Hearts, Reese's Cups, Reese's anything, the Easter egg shaped Reese's are the best.
Dude, they're different.
They have the best peanut butter to chocolate
Yep.
ratio of any Reese's ever made.
They're different. It's got to be different chocolate or different peanut butter. I don't know. Now I do have to say,
It's the amount.
My mom and her siblings for Easter and for Christmas, like they have random, and it's really sad because like people die, and so now we're just down to my mom, my uncle, and my aunt. But they have like a tradition where for Christmas Eve we have raviolis, and they make homemade raviolis for everybody for Christmas Eve dinner, and they're so good. It took years for them to like make them a good way. Like it was a little hairy there for a while. Like the noodles were way too thick, and there like wasn't enough cheese. And oh, you had enough? Okay. But one thing I'll say that they like are getting better and better and better is for Easter they make their own.
How do you open these?
Like Reese eggs, peanut butter eggs.
How do you open
And they're ugly, man, but they're so good.
How do you open
peanut butter balls during the holidays?
Peanut butter balls.
We are prone to random outbursts.
Yeah, I have one of those too. Oh my god, I love donuts. I love we call them long johns, or at least we did in the Midwest. I don't actually even know what they're called, but they're the long ones with like the caramel on the top or the chocolate on the top.
Mm-hmm.
Those are my absolute favorite donuts.
I like the kind with like the pudding inside.
Oh, like a custard, like the custard filled one.
Yeah.
Do you like a jelly donut? Because I cannot stand jelly donuts.
I do.
Those are
I
so
do,
bad.
but I'd be pissed. Like if I bite into one and it's got that like white, creamy, whatever that is, oh, forget it. I'm throwing it away and I'm pissed.
The Boston.
It's like oh, disgusting. Stop it.
Oh my gosh.
I don't even know what it is. I don't know what it is.
I do. I love pastries, and I have a problem. Oh, really? You're gonna bring some donuts? That would be amazing. Yeah, yuck. Jelly donuts, yucky. The custard ones are good, but the long johns are the best. That's why I said I don't even know what they're actually called, but that's what we've always called them. So, the favorite candy bar is a whatchamacallit. Have you had a whatchamacallit?
That I've seen that, but I've not
You
eaten
gotta
it. I
have
know
it.
the one time we really don't keep much candy. The only reason he has candy right now is because he had Easter at my mom's, and she got him. Of course, the one thing she got him that was like really useful, which I had never seen before, was it was like a sucker container, like it had a hole in it for the stick. And it was like a dinosaur or something. And it would keep them fresh. Because you know how they'll like take a couple licks and then they don't want to know more. But then later they want it. So instead of him sitting it on my coffee table, we could put it in this little container.
Okay.
And I thought that was cool. But he's got candy. But the one time, because he like can't read. And so it was like the middle of the night. And I hear, oh, disgusting. And I come out and the liver. Here he's in the kitchen in the dark. I said, "What is it?" He said, "I thought these were M&Ms. They're not. They're Skittles." Like woke me up out of a dead sleep. Oh, disgusting! I was like, "You should be in bed." Like, how many times do we have to have this conversation? Like, he's real bad with like, he's growing. Okay, when I say he's growing, when my child was born, I didn't think I was going to have a problem having a baby. Like, my hips are made for babies, but not this baby.
You got birthing hips. Brian Koberger would like you.
Yeah, for real though. Not this baby.
Birthing hips.
Listen, I was in labor with him for like 16 hours before they were finally like, nah, we don't think his shoulder, like he hasn't gotten past his shoulders. His shoulders can't clear like your hips. I said, do what? He was 2 weeks early, dude. I was like, what do you mean? And they're like, yeah, and like your temperature's going up, the baby's heart rate's going up. So, and this, I had him at a Catholic hospital. And so they try to avoid like C-sections at all costs. So they let me suffer for all that time. And then they were like, so we're probably gonna have to have a C-section. Anyway, when he came out and they put him in the warmer, he took up the whole warmer. He looked like,
How much
I'll
did he
send you a
weigh?
picture and he'll die. He was 9'10"
Woo!
and 27 and a half inches. He looked like a toddler. Now, granted, they did tell me that some of that was from like fluids, because he and I both got a lot of fluid. I mean, we were there for a long time, obviously.
Right.
But he was, I mean, he's built like a brick shit house. I swear to God. He's 6 years. He's always been bigger. Like, he's just stout and tall. And he gets in these like moments where he's growing and he'll eat everything. Like, he'll get his Uncrustables out of the freezer and like eat them half frozen.
Oh, I do that. I eat my Uncrustables
Like a whole
frozen.
box. A whole box. He'll eat like 6 bananas.
I love bananas.
Yeah, I know.
But you don't like Skittles.
Hates them.
I only like M&Ms, but they're related.
Literally, he was like 7 months old, and I can
Did he walk over?
I can vividly.
Did he have teeth? Did he have teeth?
No, oh my God, no. Somebody told me that was actually a thing. I
It is
don't
a
know.
thing.
I
It
have
is
a real hard
thing.
time
I think it's
keeping
the
like,
weirdest
a
shit.
straight,
My
normal
kids didn't
face.
have teeth, but I've heard of people's kids having teeth. Did anybody in the chat, did your kids have teeth when they were born? I don't know why I find that so
Absolutely
freaking odd. Like, I feel like they're gonna, like, they're born with like their grown-up teeth, and like it would be weird as shit.
Someone said that to me, and I'm like, surely that's not a thing. So I looked, and like it really is.
It is. It is
And
absolutely.
It was
a
like,
thing. My son had.
if you
teeth
look
right
it up, you're gonna be
now.
like, what the fuck?
Yeah,
They look
it's
like,
weird.
that is a bad word. I didn't say the whole thing though. As long as you don't say it.
I'll email you a link to my favorite donut shop. Choose your favorite, but I would suggest you try the piercing as well as the long john. Okay. Well, I ain't mad at that. I'll try it. Thanks for the night. Yeah, babies with teeth.
Mm.
Can I pet that dog?
It really is the stuff of nightmares. By the time I had him, I had been sober for years. And so I was like freshly, like, obviously when I went in there, I was like, give me all the drugs. I want them all. And we had to drive. So the closest hospital, which is the one we had, was 45 minutes away. And like, I was assured that your water doesn't break like it does in movies. Like they were like,
That's a lie.
yeah, they're like, oh, it's like, that's like only in movies where like suddenly.
Shamita's pregnant right now. She's like, if this baby comes out,
I feel like that's something they should check for when they do their like pre-testing of the babies.
Right.
I'd be like, I'm gonna need to know if this baby has teeth before it comes out. I need a warning so I can get like, so I can accept this before I have to look at them. But they said, it's really hard to tell. Like it can be really hard to tell, like when you're in labor, blah 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 blah. My mom, she lives 7.5 hours away. She came down. She was hoping and praying to God I would go into labor that weekend because I had been having contractions for like forever, like in my belly. And she left and she drove the like 7 hours home. She just got home. I was like, okay, now that you're home, I'm going to go to bed. I literally went to go pee before I went into bed. And I walked in. I said to my ex-husband, I'm like, I think something's going to happen. And he was like, what? Like, I just took my nighttime medicine. And I was like,
You're
oh,
like, too bad.
yeah. I'm
Too
like,
bad.
yeah, you're probably good. It might not be till the morning, but like something's about to happen. And Teresa, I swear to God, it was like me laying my head on the pillow, like triggered a needle to pop out and just pop my water, and all of a sudden it broke. And so I called the nurse, and I'm like, so my water just broke. Definitely just broke. Not like how they said it would. Like that, it definitely broke. And she was like, okay. She's like, just get in the car and drive here. We'll be ready for you. You know, come to this entrance or whatever. And I'm like, okay, like as soon as it stops, like I'll come. And she laughed at me and she was like,
No. It's
no,
not
you're gonna have to
gonna-
leave now. And I'm like, no, I'm not getting in the car late. She's like, no, like that's not gonna stop till the baby comes. I was like, what? Like,
Yeah, no,
you all told me I
it's
didn't
never
have
gonna
to prepare for this.
People in chat are like, all right, we're leaving. We don't know. I know women talking birth stories, but it's true. My
We
water
threw the
only
car
broke
seat
with
at the
my-
car.
with my first one, and my husband, when I told him my water broke and we needed to leave, he was like, "Do we need a towel? Like, do I need to put a towel down in my car?" I'm like, get the fuck in the car. We need to go to the hospital.
Yeah, well, like I was fine. Like I was fine. I was like excited. I'm like, okay, I'm gonna get the car seat. Like, so he tosses it in the car, and like we get in, like we pull out the driveway. I'm like a mile to the interstate. By the minute we hit the interstate, dude, I was in full blown like contractions, nonstop, strong,
How
and
do-
I was
How did
blessed
we go
with
from
back
Skittles
labor that
to
nobody told me
childbirth?
existed.
How did we go from Skittles to childbirth?
Because my child is here. I honestly don't. It was because he's tall and he eats a lot. That's how he got here.
That's how we got here. But he doesn't like Skittles.
He does not like Skittles. That was like the last food on earth. He would just starve to death.
That is an absolute fact. It's very hard to gross me out now.
I have to say,
I deal with a lot of yuck from tiny little people who should not have that much yuck inside of them. I mean, the amount of yuck that can come out of a tiny person is I don't even understand it.
I can honestly say he was not like
You didn't
I
have,
was
like,
very
blowouts?
blessed. No, I was like very blessed.
Oh God, I went through blowouts.
Or I was
That
like
terrible.
overly. I might have been overly, like I had him. The biggest issue that we had was like his sensitive skin, which like I was not expecting at all. So like he had to have the most expensive diapers, Pampers sensitive white. Like he literally couldn't have anything besides that. And I found that out the hard way. And I was like, I think I cried more when like my kid's butt got raw from cheaper diapers.
Oh yeah.
But other than that, like it was suggested to me. See, I wanted to breastfeed him really badly. Like I had prepared myself for it. I bought everything I needed plus extra. And he was so big. I just like, I literally couldn't, like I was feeding him. And then, so that,
It was like, give me a pizza, Mom.
So like they say that the time that for them to eat, like doesn't start when they when they finish eating, it's when they start, right? So he was eating every 45 minutes to an hour-ish. And so, but he would eat for like 20, 25 minutes. So like there was literally nowhere for me to sleep ever. And I was like, I called my mom and I was like in tears. And I was like, he's going to get jaundice. Like I can't keep feeding him. Like I don't have enough to feed him. He needs all the food all the time. She was on her way and I was like, you have to get him formula. You have to. Like, he's going to die. I don't have enough to feed him. And she was like, calm down. And then I was like crying because I couldn't breastfeed him. Like, I'm like, maybe if I just keep, she's like,
you're an emotional disaster at that time.
So she did on her way back. She like got him formula and he had that. And like, of course that didn't help in terms of his chunkiness. He wasn't chunky. He was never chunky, but he was like, every time we'd go to his appointments, they'd be like, well, he's in like the 99th percentile for height and weight. Like every time he'd be like, wow, he's getting big. And I'm like, getting big? Like he was huge. I'm gonna send you the picture of him in the warmer. I was dumbfounded. Like they gave me obviously I asked for all the drugs. They couldn't give me them. They couldn't give me them because they needed to wait for blood work. And it was the middle of the night and it was snowing. So then when they came back, they're like, the blood work's okay, but like we have to wait for the anesthesiologist to get here. And I was like, do what? Like somebody's not here?
Yeah.
And she did come in the middle of the night. She was super nice. She gave me the epidural, but then she was like, like I can leave it here if you want. Like, but I feel like there's like a better spot. Like, and I was like, just do it again.
and I was with my third one with my littlest, they missed with the epidural. Oh my God. It was the most miserable childbirth ever. And I thought I was dead. I literally just told them, tell my children I love them. I'm leaving now. Like I was done. I thought I was dying. Part of it I don't even remember. I think I was completely out of it. It was my husband will tell you, he's like, oh my God, you were so embarrassing. I tell the nurse, because the doctor was doing a C-section at the time. And so but I was ready to deliver and they would not let me do it because the doctor wasn't there and I was in miserable pain. So I was like, he's like, you were so nice to the nurse. And you're like, so you're going to get the doctor for me and you're going to help me. And then she was like, no, the doctor can't come for like another 30 minutes. And then you're like, get the fuck out of here. You're not fucking helping me. He's like, it was so embarrassing. It's like,
I really tried. And all I kept saying to everybody was like, if I would have just if the contractions would have stayed in my belly, I could have did this. Like I could have did nobody told me that back labor was a thing. Like I was not prepared for that at all. And I first of all, my nurses were amazing, but the doctor was like one of those really bizarro, like super, super smart and incredibly awkward socially. What was it? Peter Power. That was his name. But he was a great doctor. But I died too, like when I had him. So like they gave me that epidural. I let her do it again because I was like, I'd rather her just do it. I couldn't feel it anyway. I was in so much pain. And I'm like, just do it again. And she did. And I'm like, so how long before this starts kicking in? Cause like, I'm really over this by now. And she was like, every contraction after this one should feel less painful. So she's like looking at the meters and stuff. And she's like, okay, like you're having a really strong contraction. I'm like, what? Like, I don't feel anything. This is great. Like, but
when they actually work, they're amazing. But like first two, they worked. My third one, it didn't. And I was like, I don't know how people why would anybody purposely do this?
Absolutely not. I want all the drugs.
Never do this ever. They're like, no, go all natural. And I'm like, oh, fuck that. All right, people are coming in. They're like, I don't even know what the hell we just walked into.
Sorry. They're like, babies don't need their drugs. I'm like, baby's on his way out. He's not going to be addicted. He's fine. All right, let's keep reading. LG cell phone. I got pictures to send Teresa here after a bit.
Yeah.
All right. On February 15th, 2017, Lieutenant Brian Bunner of the Cybercrimes Unit of the Indiana State Police conducted an extraction of data from Liberty's cell phone using a program called Celebrate. Said information was downloaded via Celebrate, and several reports were generated therefrom. When the defense was unable to locate in discovery the data from Liberty's phone, it sent an email to Prosecutor McClellan on June 17th, 2023, requesting a copy of that data from Liberty's phone, as it had not yet been provided to the defense. Clearly, the state of Indiana possessed the 2017 Celebrate extraction and data on the date they filed charges against Mr. Allen, October 28th, 2022, as well as when the defense requested the data from Liberty's phone in its June 17th, 2023 email. Despite being in the state of Indiana's possession for over 5 years when charges were filed against Mr. Allen on October 28th, the extraction and data from Liberty's phone was not provided to Mr. Allen's attorneys until September 8th, 2023, 9 months after it was due to the defense. However,
why would they? I mean, that one seems to be like it would have been this is the stuff that doesn't make sense. These things that they had from the get-go, they had them for years. None of this has to do with like the stuff that's still being investigated or new. This is all the really old stuff.
It's the things that you would think would have been referenced, like right when they were going to make an arrest. So they would like be on the top of the pile.
Yeah, it's already ready to go. I mean, we've already prepared for, for a trial for 5.5 years. Like, we're ready to go. I don't understand why they wouldn't have gotten the information from Libby's phone until September of 2023.
Yeah, me either. Well, and it's not just the 2017 dump. So it says, however, even upon receiving the extraction and data from Liberty's phone, the defense was unable to immediately focus on that important piece of evidence, as the evidence was just one small part of a much larger series of evidence dumps that the state of Indiana chose to turn over to the defense in a roughly 4-week period between September 8th, 2023 and October 6th, 2023, more than 9 months later than required under the Indiana Rules of Criminal Procedure. Included in the 2017 Celebrate extraction of Liberty's phone was a video purportedly taken on February 13th, 2017 at 2:13 p.m., containing images of Abby and a purported suspect. The state of Indiana failed to produce this extraction to the defense until September 8th, 2023, 9 months later than discovery rules mandated. So now the video of Bridge Guy.
And
Additionally,
pictures of Abby.
Additionally, in 2019, Indiana State Police, perhaps with outside assistance, conducted additional extractions of Liberty's phone, utilizing different software programs. These newer extractions have been discussed by Indiana State Police officers in depositions, but has not been located in any discovery provided by the prosecutor in any usable fashion. The defense has requested the state of Indiana to provide the locations of these newer extractions. Additionally, a certain extraction software program called Axiom has been provided to the defense. The defense has been unable to open said extraction, but apparently needs some type of special licensed program in order to open the extraction. The defense believes that the state of Indiana has not provided the special program.
Okay, hold on. So the defense is unable to open this particular. So this is different, though. Okay, so in 2019, they get outside assistance. Those newer extractions have discussed, but not located in any discovery. Okay, provided by in a usable fashion. Okay, I got it now. The defense has requested the state of Indiana to provide the locations. Additionally, a certain extraction software called Axiom. So are they saying that this is that 2019 dump? Is this Axiom dump?
Yes. So the Axiom dump is the 2019 dump that needs a special program to read it, and the state didn't turn over the program in order to read it.
Okay.
As part of a reasonable investigation, the defense would have wanted the opportunity to compare the 2017 extraction to the 2019 extraction to see what differences might exist and the reasons for those differences, and would have further wanted to exercise that opportunity on or before December 14th, 2022, when the state of Indiana was required to turn over all extractions of Liberty's phone so that the defense had as much time as possible to analyze Liberty's phone extractions. So what I compared this to was kind of like with Jennifer McCabe's stuff, like Celebrate updated, and then it showed supposedly things that apparently wasn't seen on the first one with the older software.
Okay, but they didn't even the second dump in 2019 is through a completely different software.
No, I know, but they wanted to compare the two to see what was found in 2019 that wasn't found in 2017.
Because it's like a newer version of software, so they're like, okay, let's see what's.
Yeah, and different. Like maybe it pulls so maybe the one in 2019 is capable of pulling this is just an example. Maybe it's capable of pulling like deleted DMs on Instagram, but 2017 Celebrate wasn't. You know what I mean?
I got you. Okay. So they do it, the new software comes out, they're like, all right, well, let's just dump the phone again, see what we can find.
Yeah, but isn't 2019 when Could could that have had anything to do with Keegan Klein or no? Like why 2019?
Maybe that's just when the software came out. I think Keegan Klein was end of 2020, but we didn't know about him really until 2021. Somebody in chat who's more into Keegan Klein stuff will know, but that's what my memory is telling me, is that he was actually arrested the end of 2020, but it became public in 2021. But I could be wrong on the years, so somebody will tell me.
I don't know why 2019 is sticking. Well, 2019. Okay, so 2018 is when they started bringing in Messer and Fields and the sisters and so I guess maybe if it was like January 2019, that would make sense. But again, I don't know what they would.
Also, 2019 is the big switcheroo on the sketches.
Oh, yeah, that's why it's sticking out.
Yeah, it's also, they do the 2 press conferences, the one in February and then the one in April.
Interesting. Well, so basically, so they say there's no justification for submitting the 2017 cell phone extraction or any other of the extractions in data 9 months after that was due to the defense, especially when the state of Indiana had the evidence in its possession for almost 6 years prior to charging Allen. This gets like more serious.
Okay, so extraction and data 9 months after that was due to the defense, especially they had it for 6 years. There is no that's what I'm saying. Like, this is the kind of stuff that should have immediately been turned over. It was done. Okay, yeah. So that's Libby's phone. So now we've got some random video of a potential dead guy with potential cops. We've got them not turning over the software in order for them to access this 2019 extraction, is kind of what I'm gathering from this.
We've got a suspect in Florida with blood on his jeans.
Suspect in Florida. Yeah, third-party suspect in Florida with blood on the jeans. That we don't even know if it ever got followed up on. So they're wanting to know, and that randomly just shows up in the middle of a report of the discovery. Okay.
And you already said the 2019 so the 2019 extraction, they can't read at all.
Yeah, so they have no idea if anything is even different.
Right.
Oh, hold on. So the missing C was about grand juries, by the way. It didn't apply. Oh, because is it a template? Is that what it is? Miku's headphones? I mean, they're writing it. Like, they wouldn't. I don't know why it wouldn't. Is it a template then?
I swear his ass is pulling templates and just going in and trying to edit different words.
Well, the C is here. Hold on. What page are we on? 5? I think you might have been trying to come on at that time. There's no C. So they do this whole thing right here. Oh, because they're talking about the Indiana code. It was the statute. Okay, Miku. Thank you. Okay, that makes sense. So yeah, this code, and they're talking about the code, and I was like, well, where the hell is C, and why is it gone? Like, why didn't they put that in there? I got it now. It was a statute. It had to do with grand juries, which had nothing to do with this case. Thank you for filling in that blank for me. I needed that.
All right, so now we move on to Todd Click. And it says, contained in these disclosures was the letter and 83-page report prepared by Assistant Rushville Police Chief Todd Click, hereinafter Click Report, which was sent by certified mail to Prosecutor Nicholas McClellan on April 28, 2023. The Carroll County Prosecutor's Office signed for the certified letter and report on May 1st, 2023. Yet, inexplicably, Mr. McClellan did not disclose this highly exculpatory report, nor the accompanying exculpatory videos and other related discovery to the defense until September 8, 2023, 4 months after he received it. Rule 3.8D of the Rules of Professional Conduct, Special Responsibilities of a Prosecutor, states that the prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. The prosecution should have turned that material over to the defense immediately upon his receipt of the same. Which I agree with. And the fact that he hasn't just come right out and explained why he didn't turn it over makes no sense to me.
Well, I'm wondering if he even cared about it, if he even knew, if he even opened it. Just because we know he received it doesn't mean he actually did anything with it. for me, I'm like, I wouldn't be surprised if he's just like, yeah, whatever, I don't care about any of that. It's not important. But the thing I find interesting is that the certified letter has the 83-page report with it. The letter and 83-page report prepared by the Rushville Police Chief, Todd Click.
And videos.
And the exculpatory videos.
And other related discovery.
So he sends all of that to him, and I just thought it was the certified letter, but this makes it sound like it's all
His
of
whole
those
file?
things. Yeah.
Mm-hmm.
So then I'm wondering why then does he have to take all of that again to his meeting at the end of September with Holman and Mullen? They already have it.
Well, I think they wanted to know. So if I'm him, right? If I'm Click, my intention of sending that would be, I'm scared that he's not right. I have all this evidence against so-and-so. Like, I would have sent enough for the prosecutor to be able to write a probable cause affidavit, right? That doesn't necessarily mean all of it. So perhaps they were just wanting him to bring all of it.
Okay. I mean, that's still interesting to me so he gets this giant packet of stuff, not just a letter. It's a packet of info of, hey, you need to look at this before moving forward. And he just doesn't. Or if he does, he doesn't bother to tell anybody until after the, like, or I'd have to go back to my timeline, but the depositions
are right around until they did their depositions. And and Nick knew at that point that they were looking into all this stuff, and they would find out about Click, know about Click, and go to talk to him.
Just like the Purdue professor. Like, hey, get a hold of the Click guy. Hey, get a hold of the Purdue professor. Hey, get this stuff taken care of. Get that Brad Holder guy interviewed. Get Patrick Westfall interviewed.
Well, and Click testified to that too. He did say that he made a mention that exculpatory stuff needed to be turned over to the defense, and that was why he was providing some of it too. So even if Nick says, I don't know what all he gave to the two that interviewed him when he came in, he can't get around all of this stuff that was sent and signed for by his office.
And this has to have been, if the defense is being told about all of this on September 8th, 2023, he had to have given it to McClellan, because Click isn't interviewed and doesn't bring in his file to Holman and Mullen until the end of September, approximately September 30th. So if he's able to give it to him on September, if McClellan is able to give it to the defense team on September 8th, that means it was all included in this letter, which I find very interesting. I thought it was just the letter, but I mean, we'll keep going. Okay.
Nope. All right. There is no justification for Prosecutor McClellan to delay turning over the Click report for over 4 months after the Carroll County Prosecutor's Office received it. The delay in disclosing the Click report and evidence to the defense has resulted in harm to Mr. Allen. Had the state of Indiana turned over the Click report, videos, and documentation in a timely manner, the defense would have A, focused on certain third-party suspects much earlier in the representation, and would have then investigated this case much differently and much more efficiently. B, changed the order of deposing witnesses and would have deposed certain witnesses such as Elvis Fields, Brad Holder, Johnny Messer, Rod Abrams, and Ned Smith, Patrick Westfall, and Taylor Hornaday much earlier. C, asked different questions of law enforcement at their depositions. And D, been better prepared for trial earlier. Like, C, for me, is a good enough thing that you fucked up, because do you remember in the one where they were like, they waited till we showed up at the deposition with the cellular person to give us cellular data. We had no opportunity to look at it, to ask questions, or talk to our expert who could then tell us what questions to ask. And then at that point, like, what are the odds you're getting another deposition?
Right.
You know what I mean?
Ned
So
Smith.
that's a small one. You know what I mean?
Yeah.
Like they've been going on and on about that. There's still whatever. There's still I don't understand how we're 20 or 19 days away from trial and there's still motions from over a month ago that are sitting there with no ruling, including a Frank's motion and a motion to compel.
Jesus Christ.
Here's another one.
Well, I don't understand why we don't have any hearings at all. Like this is just going to be like right before trial. It's going to be bada bing, bada boom, all denied, no hearing, or all denied after one hearing when they're doing jury selection.
I would be adding her to the reason. I would be adding her like to whatever in terms of why they're not getting discovery, because she's doing like she's not denying it and she's not telling him to turn it over either. She's doing literally nothing.
How many days away from trial are we? So that's what, 7, 14.
I have a countdown. She's not going to grant a continuance, guys. There's no way.
We are like 19 days from trial, including weekends.
We are 20 days from the start of trial, but obviously we're getting ready to go to bed soon, some of us, and it'll be 19. That's literally nothing.
Nothing is scheduled. No, as of right now, the next thing scheduled is May 13th for jury selection in Allen County. So I just can't. I don't know. That's one of my main. I don't know why there's not hearings happening to make sure all of this is resolved before trial. But Kel, yeah, we talked about that a little bit on the live over the weekend. So the third party payment system called Stripe will no longer accept payments. They updated their terms of service apparently, and so that pay to it, I think is what it's called, pay it to it, uses Stripe as their payment system. So since they updated their policies, the fundraiser is that particular fundraiser is done. They'll be able to take the money raised, and last I knew they were trying to figure out if they were going to use a different system for more fundraising, or if they were just going to leave it where it was.
Yeah. We don't know yet.
This makes me think that they did those recent depositions that were just up, that they just did these because it says they would have done that much earlier. Not that they would have done it. It says they would have done it much earlier. So it makes me think that these guys were all just deposed.
I would hope so.
You know, with that one that was floating around the internet of Elvis's sister. Hi, Charmaine. Okay.
All right. So, terms of Mr. Allen's imprisonment and early trial considerations. The fact that Richard Allen remains trapped in solitary confinement in the Secured Housing Unit, or SHU, of both Westville Correctional Facility and Wabash Valley Correctional Facility while on pretrial detention has caused a physical and mental deterioration of Mr. Allen, causing defense counsel to seek a speedy trial rather than risk their client facing further mental and physical deterioration. The fact that the state of Indiana has violated rules of discovery through very late disclosure of large volumes of evidence, including evidence that supports the theories of innocence, has put the defense in a precarious position where it could have, 1, kept the October 2024 trial date and then spent the next 6 to 8 months reviewing late evidence that the state of Indiana had in its possession at the risk of continued deterioration of their client's physical and mental well-being, or 2, seek a speedy trial and hope that they can put the case together in spite of the significant discovery violations perpetrated by the state that have put the defense at least 9 to 10 months behind where it should have been had the state of Indiana followed the rules. As a basis for understanding the impact of solitary confinement for even 2 weeks on a human being, let alone 16 plus months, the defense cites the United Nations findings on that topic. The United Nations standard minimum rules for the treatment of prisoners Rules 43 and 44, prohibits the imposition of solitary confinement for prolonged periods, defined as periods of 15 days or longer. Additionally, per the UN standards, solitary confinement should be prohibited in the case of prisoners with physical or mental disabilities when their conditions would be exacerbated by such measures. That's Rule 45. And then they cite where it is, comes from the United Nations Standard Minimum Rules for the Treatment of Prisoners. The decision to seek a speedy trial was not hastily made, but only decided after factoring in that Richard Allen has been languishing in solitary confinement for well over a year, approximately 536 days, or 521 days longer than allowed by the United Nations, which equates to more than 20 times the standards set out by the United Nations, and continues to suffer both mentally and physically. The defense fears that delaying the trial will result in continued and prolonged mental and physical trauma to Richard Allen, or even worse. Choosing a speedy trial and dealing as best as it can with the fallout from the state of Indiana's late discovery disclosures was and still is a better option than risking Richard Allen's well-being by prolonging the trial date to October. I don't know how they keep making that.
That's tough, though, because if you're not prepared for trial and then you lose, that's not going to help his well-being.
Yeah, they bring that up. Like, you know, they really they're putting the fact that they keep saying this over and over again about his treatment, and like the state doesn't even object really to him being moved, and she just won't move him, is like beyond comprehension to me. And they're basically saying, because like he won't turn shit over, you won't make him turn shit over, and you won't let him be moved. If we want him to go to trial, like alive and competent, like we have to do it. You know what I mean?
We have to do it now. Otherwise, his well-being is gonna be gone.
Which I almost feel is like part of like the tactic. You know what I mean?
I think a lot of people feel that way. That's the whole thing I've always said is, okay, even at the beginning, if this was happening, once they had the setup, why did anybody argue against him being moved? That was the bigger thing to me, was why they were so adamant not to move him. Why did they care so much not to move him?
Yeah, I don't know.
So I'm saying, like, even at the beginning, if they really felt like, they couldn't take care of it, that there was no way they could protect him, that, this was going to be better. I don't
know either.
I don't know why that's when I thought, okay, like there's something in it for them. They need him there for a reason. They don't want him to be out of prison for a reason. What is it?
Well, the statements and whatnot, all of the things that they're complaining about his treatment, all break you down to where I think they'll think that they'll benefit. Whether it be him wanting to plead guilty or, you know what I mean?
Either have him dead, confess, or plead. Either way, it's all done to them.
Like, he's racking up like multiple incriminating statements, I guess, which like really makes me wonder how compelling this phone call with his wife was, because he literally said that he admitted to killing them, admitted to the crimes as charged, made a big deal about it. People constantly talk about it. Why then need to have all these people come and testify to all this stuff instead of just playing the recording for the jury? You know what I mean?
Of the confessions?
The one, yeah, to his wife. I mean,
I'm play any of them. Play them all. I mean, if they end up coming in, I think they should play them all. They should see the conditions that he's in and prove that either Nick is right or the defense is right.
Yeah.
Here, they say he's on camera 24 hours a day.
Well, the problem with that is then if there's anything said or done by others, that's also on camera. You know what I mean? As opposed to just having them testify.
Like, do you think they actually have those videos?
I don't know. I do not know. Want me to keep going?
Yeah, you can. So,
all right, so now we're requesting sanctions. As a sanction for the belated disclosure of the report drafted by Assistant Rushville Police Chief Todd Click, the defense requests that the jury be instructed that Assistant Chief Click's report contains evidence tending to prove the innocence of Mr. Allen, and that the prosecution failed to turn over that evidence to the defense in a timely manner. Further, the defense requests that the state of Indiana be excluded from rebutting any information presented by the defense and contained in Assistant Chief Click's report and accompanying videotaped statements. As a last sanction for the delayed discovery of the Click information, the defense requests that it be able to play the late discovered video evidence of any witness it chooses to the jury without objection from the state of Indiana, foundationally or otherwise.
Okay, so this reminds me of the case when this very first started coming out that we didn't have. Hold on, I got a cough. When this very first started coming out that they weren't getting all this evidence and stuff, and I was looking up. Remember the case I was talking about that it was that the judge ended up having to decide that the jury instruction was going to be that if the missing evidence or anything that was turned over as late discovery, that whatever the defense theory of it was had to be just interpreted that way by the jury, because there was no way for the prosecution to say otherwise, because they had lost the evidence or not turned it over in time, so it wasn't allowed in.
Yeah.
So I can kind of see where they're going with this, because that was that. I'm trying to remember what fucking case that was. Now I think I sent it to you like months ago, but so you're saying like tell the jury, they can't say that we're wrong in our assumptions of what Click's report says, because they didn't give us the discovery in time to be able to actually vet all those things.
Yeah.
Chris is saying the Odins were cleared. That they were not. I don't know.
No,
I know there's somebody out there spreading that kind of stuff, but
yeah,
no, they're not cleared. They weren't cleared by anybody. If they were, then they would have had that already out there, and it wouldn't have. We wouldn't even be here. We wouldn't even be talking about this if they had been cleared. Which is why, in my opinion, you don't see a lot of Ron Logan in here, because they believe he was cleared. I know somebody will disagree with me in chat on that, but no, they've never been cleared. But like I said, I know that somebody's out there trying to say that because they have, their inside sources with no proof. And some people on the internet don't care about receipts, and that's fine. I'm just not one of those people. I do care about receipts, and I don't care about conjecture and made up bullshit from inside sources. If you've learned anything, I don't take any of that shit seriously. It's a rumor.
We'll find out at trial.
People on these YouTube streets, man, they lie. They lie.
Like rugs.
They lie and they make stuff up.
Mm-hmm. Mm-hmm. All right, I'm going to keep going.
That's why that whole theory is trust but verify. If you can't verify, you can't trust it.
All right, it says in Indiana Trial Rule 37-2B states that if a party fails to obey an order to provide or permit discovery, the court in which the action is pending may make such orders in regard to the failure as are just, including prohibiting it from introducing designate matters in evidence. As a sanction for the late discovery or non-discovery, Mr. Allen requests that all data from Liberty's phone, including videos from all data extractions, be excluded from evidence. So that's like I've been saying to people, like, the whole purpose of having set a discovery deadline. So trial by ambush, like, is not a thing. So you go and you say, we need a discovery deadline, like a reasonable time prior to trial where everything needs to be in. And the only shit that can come in after that is like shit you just got, right? To me, turning stuff over after that deadline from 7 years ago that is key pieces of the investigation that happened is unacceptable. And the whole purpose of asking for that discovery deadline is after the deadline, all this other shit, like they can't bring it in. They can't introduce it because they didn't turn it over in a reasonable amount of time.
Well, it is interesting because what they're saying, there was a discovery deadline. It was November 1st, remember? So like she gives them the discovery deadline, but what the Indiana rules are that they have 30 days to give them the information and evidence that supports them arresting him. And some of these things, and people are going to be like, well, that's just dumb, they gave him the discovery deadline till November 1st. Well, the point is some of these things, such as the video and the stuff from Liberty German's phone, is talked about in the probable cause affidavit. So that's when it goes into the requirement of the 30 days. It's the initial stuff that they use to get this warrant. They don't even turn over that evidence until September of the following year, 9 months later.
It should have been readily available. You should have just been reviewing it to write the PCA.
I think that people are going to be like, well, that it doesn't make any sense. And it was turned over before November 1st. But I'm telling you, they used it and they said that in this audio and in this video, you can hear the girls say that there was a gun.
There was a man's voice that they're saying is Richard Allen.
Right.
In the video. Why would you not turn that over or think you needed to turn that over? Or the data that shows like her movements to even prove that her ass was on the bridge at that time. Or her phone was, right?
Mm-hmm.
Like, this is pretty basic stuff. And that's why they keep writing these things out. Like, are you going to do something? Like, you made a discovery deadline. Are you going to do your job?
No. I don't think she's going to do any. I don't think she'll have any sanctions. I don't think it'll matter. I think she'll say, no, it was done by November 1st, and that's all you needed. That's what I foresee happening.
What the fuck ever.
I mean, we'll see. Like I said, we're 19 days from trial, so we've got to start seeing something happening. I don't know. I just feel like it's going to be such a shit show.
Nick just pretends like the stuff that they said, like, he wrote that whole response and had nothing to say about, like, covering himself in shit and eating it. And I in my head, I'm just like, I feel like him, and I almost, at this point, I kind of feel like Gull is kind of like, has some people's opinion on this, which is just like, oh, well, like, what do you expect? He's in prison. And totally ignore the fact that he's not supposed to be in prison, number one. Like, when is he even able to meet with his lawyers? Nobody's paying them, and now they got to drive 8 hours round trip to go see him.
Yeah.
Through a door, a steel door with a little slot in it. Like, what? Like, how are they supposed to be getting anything done?
So here's my question then: if he's under the safekeeping order, then where are they going to house him for trial?
Yeah, I don't know. I do not know. Like, none of this makes sense. Like,
how are they going to keep him safe for trial?
I don't know. What is the deal with the money? Why is no one like, the auditor literally responded to my email and was like, can't tell you how public funds have been spent or how much has been spent out of the budget so far, because it's covered under the gag order. You'll have to file a motion with the judge. I was like, are you fucking kidding me? What do you mean file a motion with the judge for public funds? What are you saying? And the problem with that is that You can then go above her and then go above them. But what it ultimately comes down to is, are you going to take them to court and sue them for it? I don't got time for that. Like, I'm almost wondering if, like, is all the money spent? Like, I'm just not understanding why we're being stingy with funds, but yet Nick's hiring like 3 experts to testify to the same thing. And like, it just doesn't make any sense to me.
No, he's just saying one of these 3 might be the one. So good luck figuring it out.
And the defense is like, can you just tell us which one so we can depose the right one? Like, we don't have unlimited funds.
Yeah, we don't have unlimited funds. And there's only 2 of us and 2 other people who are getting paid $15 an hour, but they're capped out. So now we're going to do this shit for free.
Yeah, like, I don't know. So now this part, now they're talking to the judge. Additionally, the defense believes that there are multiple documents which still have not been disclosed to the defense, or that the defense cannot locate in the massive discovery provided to the defense. This includes the following. On November 4th, 2019, the state of Indiana sent a geofence warrant to Google requesting activity from any device in a specified distance and within a specified time of the area in which the bodies of Abby and Libby were located. So now we know the geofence stuff happened in 2019, not 2017. So it took them 2 years to get a geofence. On the same day, it appears Google returned data in a spreadsheet which contains 18,632 lines of data, each relating to a particular device ID. Generally, there is information received in follow-up requests which identifies subscriber data with device IDs. To date, no such spreadsheet or data has been located by the defense, nor can any such information be found by the defense in spite of requests to the prosecution. Detective Murphy testified in his deposition that law enforcement had pings and other phone information related to Elvis Fields' phone.
Hold on. Detective Murphy. We're back to Honest Murphy. Remember Honest Murphy
was deposed.
Honest Murphy was deposed. Everybody's been asking where he is, if he's going to be coming forward.
Yep. Had pings and other phone information related to Elvis Fields' phone on February 13th, 2017. To date, no such data has been located by the defense, or the defense cannot locate that information in the massive discovery dump, despite good faith efforts to locate said evidence if it exists. Standard operating procedures for evidence collection and retention for Indiana State Police, Carroll County Sheriff's Department, and Delphi Police Department. To date, either no such documents have been provided, or the defense cannot locate that information in spite of requesting said information from the state of Indiana. Dude, that should take 30 seconds to print off and give to them.
Okay, so just the standard operating procedures for how they collect and retain.
Yep.
Evidence.
Yep. For state police, Carroll County Sheriff's Department, and Delphi Police Department. That's it. Chain of custody documents related to the bullet purportedly found near the bodies of Liberty and Abby. To date, no such data has been.
Still no chain of custody documents.
No such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana. So no chain of custody documents for the bullet. Chain of custody documents related to the sticks, branches, and bark found at the scene. To date, no such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana. The defense possesses photographs of the bullet purportedly found in the ground near the body. Near the bodies of Liberty and Abby, and photographs of the bullet at the crime lab. The defense has no other photographs or video of the bullet from any other time. In the event there are additional photographs or videos, the defense requests they immediately be produced. They be immediately produced. To date, no such photographs have been provided to the defense, or the defense cannot locate said photographs in spite of requesting the state of Indiana to point out where said photographs are located in the discovery. If no such photographs exist, then the defense would request that the prosecution affirmatively state that no such photographs exist. So they have photos of a bullet in the ground, an unspent bullet in the ground, and photographs of a bullet at the crime lab, but nothing in between. Like not it being even taken. So for all intents and purposes,
it's in the ground, and then it's at the crime lab.
Bullets. Yeah. Prior to October 19th, 2023, the state of Indiana previously provided the defense a number of PowerPoint presentations, which were titled executive briefs or summaries, which appeared to be presentations providing information to law enforcement during briefings, including a PowerPoint presentation connecting Elvis Fields to Delphi. To date, since getting back on the case, no such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana.
Okay, so they
So
had
you
the
gave us
PowerPoint presentation. They gave
Yeah.
it back when they had
Yep.
to turn Discovery back over, and they were never
didn't
given it back.
Yep. Which, to be fair, they were likely given it. Like, let's just say they were given it before all of this came out and they knew they were coming for Elvis. Then when he got it back, he was like, don't send that part. You know what I mean? That's basically what they're saying. It's like, why didn't you send us back? Exactly. We know if they were smart, they have those thumb drive maps of everything. And that would be a quick way to know if whatever you had is what you still have. You know what I mean?
I'm trying to.
So now we're talking about, we're asking you for stuff that we need you to give us that you haven't given us yet. And now we also have things that you gave us and now you're not giving back to us. Yeah. So it's like less, you know what I mean?
Right. It's like we're going to give you other stuff now. The old switcheroo. You had it, now you don't.
Wait, scroll up one more because not DB Cooper said he doesn't think they have a photo of it in the ground. It says the defense possesses photographs. Yeah.
Of it in the ground, near the bodies.
Yeah, I'm assuming that meant one in the ground. And photographs of the bullet at the crime lab. All right.
Where are we at?
H. According to certain law enforcement officers involved in the investigation who have been deposed, members of the FBI Behavioral Analysis Unit, BAU, were present and engaged in the investigation of this crime. References have been made to BAU reports. However, the defense has not been able to locate any reports from the BAU agents or any other law enforcement concerning assessments of the crime scene regarding Odinism, Nordic culture or paganism, Germanic cultures, runes, magic, cult activity, or heathenism. To date, no such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana.
Okay, hold on.
I think as the worst thing ever as a prosecutor would be someone mounting an entire defense based on witnesses and depositions of law enforcement that investigated. Like that would be terrifying.
But this one's kind of worded poorly because they're saying they don't have any of this from the FBI and they were involved in the investigation and they don't have any of the BAU reports, which that one's fine. But when they add in here that there's no BAU agents reports that talk about Odinism, Nordic culture, paganism, all this stuff, well, they're not saying that the FBI agents considered Odinism. So that's where I'm trying to figure out, like, how does that tie in? So maybe there are no reports.
Well, no, they're saying that the BAU. So I'm deposing Teresa. She was a law enforcement officer that worked on this. And Teresa referenced in her deposition a report from someone from the behavioral. We know that it exists because, like, even who referenced it? Somebody I hate, I hate just saying stuff and not having the actual thing in front of me, but like something like,
Click testified that the BAU thought it was Odinism during the motion to dismiss. Why does this not sound familiar to me? And Adrian's saying the same thing. BAU did call the crime scene Nordic. Why am I where is that?
I thought for sure that, I thought Holman also acknowledged that
I
in
don't
his
know why
deposition.
my memory is not I cannot, I have no memory recall on that whatsoever.
I try not to. I usually just go back. So I'm going to write that down as something I need to look. Yeah, it was somewhere in the Franks. That's where I remember reading it too.
Okay, so
just type in BAU.
I did. It doesn't. It's only Sarah Carbaugh that comes up.
Oh, for God's sake. Or behavioral.
Should I say? Let me do Nordic.
Yeah. Yeah.
Oh, here. According to the summary of Click's investigation that he attached with his letter, the Behavioral Analysis Unit, BAU, of the FBI determined that the individuals responsible for the homicides were involved in Nordic beliefs. Thank you, guys in chat, for telling me where to go. Okay, so according to the summary of Click's investigation that he attached with his letter, the BAU of the FBI determined that the individuals responsible for the homicides were involved in Nordic beliefs. The BAU said that. This includes Trooper Holman, who told the defense that he didn't remember if the FBI's BAU unit determined one way or the other whether those with Nordic beliefs had been involved in the murders. Oh shit, I lost Sleuthy. Good memory, you guys. At least up until the timing of this filing, the prosecution has provided no evidence whatsoever of the findings of the FBI's BAU unit concerning involvement of the Odinism in the murders. None. The letter that Click sent to McClellan was the first that the defense has heard that the FBI actually believed that Odinism were likely involved. In other words, this report contained exculpatory evidence that Unified Command concealed from the defense. This information was and is crucial for Richard Allen's defense. Some of this exculpatory evidence in the forms of videos was finally released to the defense on April 8th, over 9 months later. Okay. So that is it's from the Franks, and it does. It says that the BAU, according to Click, the BAU thought the crime scene was Nordic. Interesting. Very, very interesting. Okay. I lost Luthi, so I'm going to, until she comes back, I'll just read these. And so they don't have anything that backs that up. So I'm wondering if in Nick's response he's going to be like, well, there is nothing. I wonder if Click or Murphy, if Murphy was deposed, if they had any of that. Okay. On April 16th, 2024, pursuant to the Indiana rules, defense counsel sent a letter to Prosecutor McClellan via certified mail and email requesting the above information from paragraphs 36A through H, or the identification of the location of the information in discovery if it had been previously discovered. Furthermore, defense counsel requested a response by Friday, April 19th of 2024. In its April 16th, 2024 certified letter to the prosecutor, the defense requested that the prosecutor, A, explain his reasons for failing to turn over the exculpatory Click information for 4 months when that Brady material should have been turned over immediately to the defense upon receipt. To explain his September 6, 2023 email in which he, the prosecutor, made false claims and misrepresentations to the defense concerning the identity of a Purdue professor and law enforcement's attempts to locate said identity, even going as far as telling the defense that the state of Indiana may not be able to learn the identity when at the time of the email the identity was already known. 3, explain the reasons for dumping 14 hard drives, 5 flash drives, 3 DVDs, and a certain e-discovery 9 months later than required under the statute, and thereby putting the defense at a distinct disadvantage, especially while dealing with their client's mental and physical health issues, which propelled their request for a speedy trial. The defense requests the court to order the prosecutor to explain his conduct around the issues raised in paragraph 37 above. The state of Indiana has made no substantive response to the discovery deficiencies outlined in the defense's April 16, 2024 letter, nor has the prosecutor attempted to address the issues outlined in paragraph 37 herein. Additionally, in early April, the defense requested the prosecution to provide Brady Gilio, I always say it wrong, material, if it exists, concerning certain law enforcement officials, both state and federal. The defense provided a deadline of April 15th, 2024 for said Brady material, then extended the deadline to April 19th, 2024. To date, the prosecution has failed to provide any Brady material, nor has the state of Indiana indicated that no such material exists. The defense believes that at least one key member of law enforcement has Brady material that the state of Indiana has still failed to turn over to the defense. So this goes back to what we were talking about with Click. Okay, so wherefore, defendant Richard Allen by counsel respectfully requests the following: that the above documents be produced to counsel for the defendant by 5 p.m. Friday, April 25th. The state of Indiana be ordered to turn over all the Brady Gilio material to the defense by 5 p.m. Friday, April 25th. That the state of Indiana be sanctioned for its discovery violations in the following way. This court will instruct the jury that the prosecution received certain evidence that tended to exonerate the defendant on May 1st, 2023, but failed to turn over that evidence for over 4 months, and that said failure to timely produce that evidence to the defense was a violation of the rules. Permit the defense to play any video that was belatedly produced without objection from the state of Indiana, and prevent the prosecution from rebutting the evidence that Todd Click provided to the prosecution on May 1st, 2023. There's no way that she's going to do that. Prevent the prosecution from using any data or information extracted from Libby German's phone in its evidentiary presentation. I mean, I don't know. They use Libby's phone as part of the arrest. I don't know how she can get around. I mean, she just does what she wants. But that information should have been turned over within 30 days. It was part of, like, I mean, they're saying it's part of the evidentiary presentation. There was no reason that wasn't turned over for 9 months. Now, did they turn it over and it was lost in the sea of all the discovery? I don't know. I mean, I guess that would be on Nick to have to show. That the prosecutor be ordered to explain in written form his reasons for delaying turning over the Todd Click evidence as detailed in paragraph 38 above. The reasons why he sent an email that is filled with false statements and that misled the defense. And the reasons he failed to turn over a massive amount of evidence, but then chose to turn that evidence over to the defense between September 8th and October 6th, just 4 days before requesting the court to dismiss defense counsel from the case. This request is made for several reasons, but especially to preserve the record. E, for all other just and proper relief on the premises. And it's signed by all three. And then there's your certificate of completion. So Jennifer Auger, I don't know if I'm saying her name right, she's the one that they just got to bring on. And she was the one that was, so this actually kind of makes a lot of sense too, that they're bringing up the FBI stuff here, because she's the one that they brought on so they could try to depose the FBI agents, because they don't have a right to just go around deposing FBI agents. You have to actually, and I don't remember I think that's the 2E one, if I remember correctly right now. Somebody in chat will correct me if I'm wrong. But you have to be able to request to be able to interview them and get it approved, and that she's the one who knows about that. So this is an interesting one that they're bringing it up here, and she's the one who wrote it, to say like, hey, they do know, and there should be some documents that say, hey, this is, the FBI BAU unit thought this. We've heard, that they did a profile. We've heard variations of what people think the profile was. And then the defense comes out, I guess, like in September and says that, yeah, that according to Click, the BAU thinks it was Nordic. Holy shit. And you have the FBI. You have this FBI task force that Click is working with Ferenczi and Murphy, all coming out and saying that it's Nordic, and then those are the ones that are being just told to like go away. Wrong case, you think? Maybe. I don't know. It's possible. Yeah, so the jury can hear about Ellie lying to obtain warrants, manufacturing evidence, or digitally penetrating an inmate. Cough, cough. The stuff Gold denies defense arguments is the exact same arguments other judges go nuts on the state for violating and penalize the state for violating. I mean, is she even gonna say anything about this to him? Is this just like all gonna be swept under the rug? Is this just not gonna be a big deal? It's frustrating. It's frustrating that we're this close to trial and there's still such a disaster. And I know, I mean, it's like I said earlier, a lot of this is not uncommon. It's just such craziness in a case where they had 5.5 years to put all this together, and there was no reason that some of that evidence wasn't turned over within 30 days. There's no reason. It just doesn't even make any sense. Why would you not turn over the phone data? Why wouldn't you get that until September? And remember, in September, trial was actually scheduled for January. So they were still only a few months out from the next trial will be better. I think he'll be dead. And I just keep hoping that there's, the pro-prosecution side of things keep saying, they believe that there's more, that they have more evidence, I just don't see it. I don't see that there's not going to be some bombshell that we just don't know. I think they're going in with what we know, and I think that what we don't know is going to be more of how they're going to present the information. But I just don't think that there's any bombshell anything. Bob's going live in 45 minutes. Is he going live on Delphi, Cleveland Rocks? Is he going to talk about these? Since the D isn't opposing the Click records, I'm thinking opens the door to other LEO records. Click probably has a spotless record. Well, there's a reason Nick is asking for it. But what it is, I don't know. But I mean, there is a reason. But that was one thing that we just read in here, though, too, is that they are insinuating that one of the key law enforcement officers. Has anybody looked up on the Brady list to see if any of the law enforcement officers are on the list? Like the Holmans, the Liggets, the Doolins, any of those guys? Bob on Delphi, these filings. Okay. Well, I'll be done by then anyway, so I'll be over there to watch. I'll probably be cooking dinner when he's live. They are doing a great job of making sure that, or trying to make sure that there is a record for appeals, but I don't think it'll matter. And I think that's kind of the whole point. And I know people are saying like, this is like an excuse for the defense so they can try to push it out. But what they clearly are saying here is they have two options. They have two options, that it is to push it out, or it's to go forward and hope that their client, they can do well enough. But if they push it out, then they're worried their client's going to die. So I don't know. I think that she's going to have to make some decisions before they can make some decisions. If she goes in there and sanctions the prosecution, I don't know why they wouldn't need to. You know what I mean? They wouldn't need to push it out. So I don't know. I don't really either, but I know that there's a lot of people who believe that. What they're trying to do is show that, hey, these guys, there's no following of procedures and protocols happening. There's no following of Indiana, statutes happening, or code happening. The state is judicial code. The state is clearly trying to delay and delay and delay. At this point, I feel like they're both ready in their own right. Oh, I know. I asked a bit ago, which would explain a lot. Is gold part of the odium? People have asked that. I have no indication that she is. I thought it was. I don't know if the site is, but I know that there is an actual list that they have to be put on. The state wanted the defense gone. Absolutely. I don't think mainstream media wants anything to do with it. That's the problem. Well, I know that there's tons of requests that have come in for cameras, and somebody was asking me this the other day in my comment section. There are tons of requests that have come in for cameras. She's denying them all. I don't know much about the state of Indiana and their media coalition, and I don't know how far they'd go. There's so many politics involved in this kind of shit. I just don't know. I don't know why they haven't requested for a hearing. They should have requested for a hearing. The defense know now who found it. They got it. When the defense calls Slick Nick to the stand, they should. I don't know. Somebody should look into that and see. And if they do, send them an email. I know. I'm sorry. I'm so tired today. Well, here's the thing: is I stayed up last night working on a bunch of graphics for Karen Reed because I was going to do a Karen Reed live today. I was going to do it yesterday, and I didn't get the graphics done. So then I was going to do it today, and then this stuff came out. So I'm going on like 3 hours of sleep right now. I'm tired. I'm sorry, I keep yelling. I think there are names similar to Idaho. Brady. Well, yeah, those are Supreme Court. Those are Supreme Court violations. So like a Brady violation that's ruled from the Supreme Court. So it could be very much the same. Nick has been dragging the families through this whole bogarting, game-changing evidence. It would be extremely fucked up, beyond fucked up. Well, I know that Anna was in groups just a few weeks ago, and she was clearly saying that she doesn't know one way or the other, that she's waiting for trial to figure it out, which was actually really ironic because she was conversing with a very pro Richard Allen is guilty, who says, like, if you don't, if you think that there's even a chance that Richard Allen is innocent, then you don't support the families. So it was a very interesting interaction watching Anna tell her, like, hey, like, I don't know. But it seems like when people refer to the families, it's almost like they just refer to the Patty family. Like everybody else is, outshined by them. Yeah, Anna said she wanted true justice, whatever that is. Ask Sean McDonough from Reed Case to come on. He said he lives talking about it, or he loves talking about it. Oh, really? I don't know how would I get a hold of him? Yeah, Anna, yeah, and Carrie too. Yeah, I know. Yeah, I don't even mean that when I say the Patty family, I don't even mean Carrie, because I don't think she's a part of that family. It is. His name's Peter. She's not going to let cameras in. I don't believe isn't going to present well for her or the state. She doesn't want it on video. So, and somebody was talking about that the court hearings are streamed, that there is like just a regular camera there. Does anybody know anything about that? Somebody was bringing that up in my chat, I think over the weekend or last week. I will be curious if how many people will actually stay outside the courtroom that don't get in. Because, I mean, the courtroom's tiny. Yeah, it's a courtroom camera, but I don't know, like, is there like a web link that is normally, like, normally on? Like, has anybody gone and watched any other case or any other hearing at that location before? That's for Allen County. I don't think Carroll County. Okay. I think it's clear. The state wanted a plea before the defense had access to all the discovery. Once all the evidence is vetted, the state will have no case. That's how I feel. That's how I feel about it. You know, I don't think they're going to be able. I'm telling you, they have this trial scheduled for 2 weeks. How much evidence do you guys think that they're presenting? She'll put her bubble gum on the lens. Well, he won't be able to stay there. He'll have to leave. If he was actually found not guilty, he will not be able to stay there. No way. OTC hearing aids for whomever is going to take notes for us. Well, the sound is better at the Carroll County Courthouse versus the Allen County Courthouse, so should be better. I don't know. So that's why I'm like, I've never looked. I've never even looked at it. I'm almost 100% positive that Anna said on video that Ellie is no longer looking for Brady. She did. She said it on the interview with what's his name? I'm tired, so my brain's like not working right. With Jason Hebert. Is that how you say his name? Ironically, right? She's actually part of the reason that we got that judges are allowed to put cameras in courtrooms. And then she's like, no, not for the most high profile case. It's weird to me. Why not put it in there when you know that the amount of people who are going to be traveling there is going to, I mean, it's going to shut shit down. Like, why wouldn't they just, less people will go, less people will travel there if you can view it. It would astound me if there's no presence of bearded bikers around that courthouse every minute of the trial. We'll be selling t-shirts and grilled cheese. Well, I was thinking, like, if people aren't, like, I wonder if there would be, like, any type of picketers, or not picketers, protesters, like how Karen Reed has it right now. Right. It'll just be chaos. And chaos for the families. I don't know. She was all for cameras when she was going to boot the defense. Oh, yeah. But then, she says that they violated her rules about them, about having the cameras. So I think that's her excuse on why she doesn't want them. I'd buy a t-shirt. Otter Woodman. You should be Woodson, so that it'd be Mr. Woodson. Because as soon as I saw your name, that was the first thing I thought of was fucking Hennessy. I'm going to order pizzas for all the folks outside for both sides. That would be probably pretty nice. Yeah, I don't know. I don't know. So I wonder, do people still think that she's going to push that the defense is going to push this out? I mean, we're 19 days from trial. Are we? Is that still a thing? Do people still think that? I can't believe we're so close to trial. There is a stream on the site for Carroll County, but nothing listed for Allen County. Nothing listed for Allen's case. It does look like Delphi has cameras. So I wonder why she wouldn't just turn those on. Like, just like how Judge Boyce and how Judge do it. She can control it and keep people out of running over the town and save the county and state more money. But she doesn't want to, which is weird. She doesn't want accountability and transparency. Even if she did like the recordings like they did with Lori Vallow's case, which sucked, it would still be better than nada. Hold on, guys. All right, that's my husband. He's like, are we gonna have dinner? She could do it. That's what I'm saying. She could easily do it just like they do. But all right, you guys, I'm gonna wrap this up, and I'll be listening over at Bob's. Sorry, Bob, I'm so tired. I'll be listening over at Bob's. He's going live at 6:45. Do you guys want me to portal you over there, or you got it under control? I can do in the portal. You just get over there early. I can do that. I'll just put it in. I'll send you through the portal of YouTube. Why is he not on here? Here it is. Okay, so when this one ends, it'll portal you over to him. He's supposed to be starting in about a half hour, so you can hang out and chat, or you can go somewhere else if you guys are interested in more info on the Karen Reed case. A couple of my friend channels are live currently. ATS News, who's a wrench here, and Deets on the Streets. Both of them are live on the Karen Reed case if you guys are interested in that. I don't know if anybody else is live on Delphi. I've really kind of cut down on how many people I will watch at this point, now that I've learned all the things that I have. So, well, thank you, Dean. I appreciate that. But I will see you guys tomorrow. If there anything else happens in Delphi, we'll do Delphi. If not, then I will do the Karen Reed presentation that I had planned for today. Other than that, you guys go and enjoy your Tuesday. I'll probably see you in Bob's chat later. And thank you guys for being here. I know that you have 1,000 other places that you could spend your time, and yet you choose to spend your time here with me. And I appreciate that very much. I'll see you guys on the next one.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one knows. We're going head into the unknown.